All right, let's come back to order. This is our second day of the Select Committee on Blockchain meeting, and this afternoon we have discussion of personal data privacy and ownership, as well as cryptocurrency mining and energy infrastructure update. We start off with a few different pieces of legislation and ideas on the personal data privacy and ownership. Mr. Chairman, this is something we've been working on for quite a few years. We passed a government data privacy legislation last year. We've passed some other legislation in the past, but there's a few areas that we're looking at this year, starting off with consideration of some legislation. And that was a little feedback. We got it? Okay, had a little feedback. Sorry about that. Some legislation that you were working on last year, and we put together a working group to spend a bit of time getting through some of the concerns that it had last year. And I think we've got a pretty good bill draft at this point in time with protected expression, limits on foreign judgments. We're going to start with a little update from the working group, and I don't know who wants to lead on that. Mr. Co-Chairman, if you want to kind of talk through a little bit about what we did at this point in time, that'd be great.
Yes, absolutely, Mr. Chairman. So this is protected expression limits on foreign judgments, which is 27 LSO 9. And this is based upon House Bill 70, which was presented in the last legislative session, in the budget session, it's with the Granite Act, guaranteeing rights against novel international tyranny and extortion. And so we've trimmed it down a bit. There were a lot of concerns in the last session about the how far this would reach, the type of applications that it would have. And so we aim to clarify specifically what we can protect as a state and what would be beyond our boundaries, at least as it would be comfortable for the legislative body that we have right now. And so this bill that we're looking at now is more of a shield. We had a sword and a shield in the previous version of it. And this is focusing specifically on the shield portion of it.
And we'll have to at least walk through it in detail.
okay.
If you just want to go over kind of the higher level concepts, what we're doing here and what the working group did.
Excellent. Yes, she will put it much better than me. But really we're aiming at having the, instead of actively preventing and inflicting some sort of damages on a foreign government that had violated the freedom of speech of a resident of Wyoming, this bill would prevent foreign judgments from being enforced in the state of Wyoming and providing a shield, the sword portion and the shield portion. And so this is focusing primarily on the shield portion. And we do have some, it is still complex. It's still dealing with our state and international law. However, I do believe that in my opinion, we are within our bounds to protect the people of Wyoming and those who choose to have corporations here or those who choose to store their data here. This is an appropriate protection for them. And so I suppose I should pass it along to Ms. Hanson.
All right, that sounds good. Ms. Hanson, you want to come walk us through the bill draft?
Mr. Chairman, members of the committee, Talise Hanson, Legislative Attorney, LSO. I am presenting Bill Draft 27 LSO 9, version 0.5, Protected Expression Limits on Foreign Judgments. This bill draft was drafted at the request of the chairman and was discussed at the 2 prior working group meetings. Mr. Chairman, would you like a brief high-level overview or more?
Kind of halfway between those two. So go through everything, but we don't need to go into deep detail.
Right. All right, Mr. Chairman. So pages 3 through 5 provides definitions of foreign judgment, foreign state, international organization, protected expression, and substantial factors. So just to highlight, protected expression means expression, expressive conduct, or expressive association that would be protected by the First Amendment to the United States Constitution and relevant constitutional provisions. And then pages 5 through 10 are more of the substance of the bill draft. The bill draft would prohibit state courts from recognizing, enforcing, or giving effect to any foreign judgment that imposes liability or compels action arising from conduct where protected expression is a substantial factor in or a necessary element of the liability or compelled action. The bill draft would prohibit the state, its political subdivisions, and its employees acting within the scope of their official duties from taking certain actions related to foreign judgments, foreign extradition requests, international arrest warrants, investigations, and sanctions when protected expression is a substantial factor in the underlying liability, compelled action, or offense. The bill draft would provide that no state entity, political subdivision, or employee acting within the scope of the entities, political subdivisions, or employees' official duties shall be subject to civil or criminal liability for any act or failure to act in good faith pursuant or consistent with this section. The bill draft would authorize any person that is subject or may be subject to a foreign judgment, foreign extradition request, or foreign proceeding to the extent the judgment, proceeding, or request imposes liability or compels action arising from conduct in which protected expression is a substantial factor in or a necessary element of the liability or compelled action to bring a cause of action for a declaratory judgment and injunctive relief. The bill draft also specifies that no cause of action authorized shall be construed to authorize the award of monetary damages or attorney's fees. And then the bill also outlines construction of the chapter on the bottom of page 10 to the top of page 11. And then the bill draft provides an effective date of July 1st, 2027. And I'll stand for any questions.
Excellent, thank you. Any questions for Talise? Any questions? Okay, seeing none, thank you, Talise, appreciate that.
Mr. Chairman.
Yep, go ahead, Mr. Chairman.
Thank you, Mr. Chairman. So I believe it is our intention to continue working on this in the working group. I love this idea. I can't really hide that very well.
It's a favorite.
It is a favorite, and I genuinely believe that this would make Wyoming stand apart. And I've had feedback from not just the national community, people looking at the state of Wyoming from the United States, but from the international community, and they're seeing the standard that we can set. This is an act of defiance when it comes to freedom of speech to the rest of the world. And so, and maybe I'm being dramatic, but I am pretty passionate about this, and so I'd like to continue working on this bill, getting more eyes on it, getting more feedback, and hearing from stakeholders. But I do genuinely believe that this will be a benefit for the state of Wyoming, and so I'd like to continue working on that.
Thank you, Mr. Chairman. Mr. Chairman, we've got a few staff comments and maybe walking through some of the language and spending a bit of time working the bill, and then we'll take some public comment, but we can start with some of that discussion. I think the first staff comment to consider is on page 7. And what it says, the select committee may wish to consider that what happens in cases where a warrant, extradition request, or request for assistance or cooperation is based on both conduct that is prohibited under paragraphs 2 and 3 of this subsection and conduct that is not. So you have a situation in which expression may be a part of what there's concern with, but then there's something which is not expression related, that there might be a foreign extradition or other request, international arrest warrant available, and whether it's an all or nothing consideration. So any preliminary thoughts there? I mean, it was my thought when we were working on the working group that it would largely be to the extent that basically the expression aspect is protected, but it only goes so far as protecting that expression aspect. So if there's other criminal behavior that isn't protected under this, so can you provide a little thought on what your expectation is there?
Sure. Well, just for a real life example, if someone were, say, from the United Kingdom, and they came and visited Wyoming, and they took part in like a shooting competition, or just were shooting some guns out on some private property, and they started advocating for that on their social media, and somehow the government got involved, That would be an example of something that I would want to see their speech protected as long, I mean, they were in the United States. They express themselves in the United States. And while they're in our jurisdiction, their government cannot come over here and tell them that they're not allowed to say those things. And so I don't, I mean, I don't think that would necessarily apply to while people are abroad in another jurisdiction. We wouldn't be able to go and validate their speech while they're in someone else's authority. However, for while we are within our borders, we can protect that speech. And so that's really what I'm hoping for here.
Is there an expectation, though, that, let's say there's just two distinct crimes, we'll start with that aspect of it, in the eyes of the foreign jurisdiction. So you steal a loaf of bread, and then you say something which would be deemed offensive in the original jurisdiction. So you've got an expressive act, which is saying something that would be deemed offensive. And then you've got the act of theft. Do you have any expectation that the theft of bread is in any way protected because you have an expression in some way associated with it? Or would we only be having this or intend to have this operate for the conduct that's specifically related to the expression? What are your thoughts on that?
Mr. Chairman, no, I don't think that this would cover the theft of bread. For an example, I'll use just let's say there's a hermit kingdom in Asia that says that you're not allowed to criticize their government, and someone managed to come over here from there, and they both stole a piece of bread and criticized their government. The theft would obviously be a crime. But we would not enforce some sort of censorship order for that hermit kingdom, North Korea. I'm referring to North Korea. If North Korea decided that someone escaped to Wyoming and said something bad about Kim Jong-il, then we wouldn't punish them for it. We wouldn't comply with what they were saying because we have freedom of speech here. And I think that's really what I'm aiming for.
But in that circumstance, if they did steal some bread back home and they were in the United States and there was a desire to extradite, they could seek support for the extradition on the I stole a loaf of bread aspect, but could not seek it for the expression. And this would not have any effect on the non-expressive aspect, but would be intended to protect against the other. Is that accurate?
Yes. Yes, Mr. Chairman.
What about a circumstance, and this is kind of, having an absolute here might be an interesting challenge if you, in that circumstance, the single loaf of bread might be, we'll say, relatively inconsequential relative to the crime of speaking out against the country, the expressive aspect. And so you'd end up having the opportunity to use the loaf of bread charges, which might just be charges at that point. Hard to say whether they're credible, as a means of circumventing the expression protection. I don't know if you have any immediate thoughts on that.
Mr. Chairman, I would just say that if someone had committed a crime in another country and the law enforcement was seeking to get justice for a crime that was committed in a different country, then that would be a different circumstance from what we're describing here in this bill.
Thank you. Talise, going to you, if we want to make it a little bit clearer, do you have any suggested language or where we would amend a bit to address that staff comment so that there's a delineation there? Or is that something we can just note and work on?
Mr. Chairman, no, I don't at this time.
Okay. We can note that one and work on it. Anyone have any thoughts on it? Any of the other members? Go ahead, Senator.
Thank you, Mr. Chairman. As I read it and, you know, we worked this quite a bit
Yeah.
through session. I mean, if you read the last sentence, for example, on 2 or 3, it says from conduct where protected expression is a substantial factor in or a necessary element of the offense, which I think that already sorts it out. I mean, that's a separate
Mm-hmm.
offense than stealing the bread. I mean, we're talking about
Yeah.
2 distinct things there. I've thought all along it covers the problem you're talking about. We're only talking about the offense that happens to infringe on protected speech, not any other offense. Now, we could add a proviso somewhere that makes that very clear, but I've thought all along, I guess, as I read it, that it already did
That
that.
language is sufficient. I'm inclined to agree. I feel like that is strong enough, and I don't read it as implying that it would be effectively a veto at that point where it gets taken out.
Mr. Chairman.
Yeah, go ahead.
I mean, but it's also not hard to add a paragraph
Right.
at the end that says this does not cover, you know, this is not intended to affect crimes or offenses which have nothing to do with protected expression.
Non-expressive. Yeah. Okay.
I mean, I think that's a cleanup for sure. It's easily done and doesn't affect the bill whatsoever, just strengthens it probably.
Right. Any additional thoughts on this staff comment?
I agree with the Senator.
Okay.
Yeah.
All right.
Mr. Chairman,
Yeah, go ahead, Mr. Pope.
in my mind, what you would do is, and we can add language to it, but the protected portion of it would be segregated and the rest of it would be treated as any other type of request. I don't see a big issue with it. I think the language, I found it to be sufficient, but you're segregating it into 2 different categories there, and the greater offense or the theft of the loaf of bread would be treated just as any other request would.
Okay. Thank you. All right. So, Talise, let's note that down that we can, as Senator Crago was suggesting, add just a little bit of additional language to clarify it, but we don't need to change the language probably on paragraphs 2 and 3. That is strong language. So maybe a little clarifying addition. All right. Anything else on our page 7 staff note? Okay. Let's go to page 8 and have a little discussion on the C paragraph, or excuse me, the lines 4 through 15 staff comment. Subsection C requires state entities, political subdivisions, and employees to determine whether a foreign judgment or other actions are based on protected expression. The select committee may wish to consider that this determination may require a complex legal and constitutional analysis that may be difficult for individual employees to make in the absence of guidance from the courts or the Attorney General. So, yeah, this is a bit of a challenge, and that works for the entire paragraph C. So that goes back to page 5. You've got some judgment. Now, I thought we have a paragraph which allows for an opportunity for an injunction. And where is that one? That is the declaratory judgment on page 9. So you can seek it if nobody has that finding for you. That's like the F paragraph. But the concept here is the idea of individuals using that judgment without having any type of court decision. So I guess it's important to think through how that is going to materialize, where I've got a political subdivision, state, federal, whatever. Excuse me, the state, its political subdivisions and its employees acting within the scope of their official duties shall not do these things based on whether they think it is the case or not. And they might not know enough. Is there a remedy for that? Or are we just, honestly, you've got a remedy on one side. You either start by trusting in your employees. So if they affirmatively decide, hey, this is an expressive action, I'm not going to do anything about it. I believe it's an expressive action. The other alternative, and there seems to be no review for that. I don't know how that would be reviewed for somebody to say, hey, I think you're wrong. On the other side, though, if they don't find it to be an expressive action, we do have a remedy. That's the F paragraph. And some of the subdivisions of that. Do we need a remedy then to question a state entity, political subdivision, or employee making that decision in good faith? And I don't honestly know that we do, but that's the question here. And who gets to say you're wrong if they affirmatively decide? So if they affirmatively decide it's an expressive action, there doesn't really seem to be a recourse, and they might not have the wherewithal of the AG's office or of the courts to really have a finding, right? It's just somebody's opinion.
So, Mr. Chairman, an affirmative finding at that point, it would be the foreign government or foreign entity that would want to appeal that, which they already can. I
They
mean,
can.
under standard appeal practices, Rule 12, appellate procedure, Rule
Mhm.
12, you can contest a local government entity decision at any time. There's a provision within the law to already do that.
Right.
I don't think we have
Right.
to cover that in this particular
Agreed.
statute. We're giving additional rights of appeal, essentially saying you can bring a declaratory judgment, which I think you could anyways without paragraph F, but this just makes it clear that
Yeah.
you could bring a declaratory judgment / injunctive relief action against the government, at whatever level, if they decide against you as a Wyoming citizen.
Right. So that, in your analysis, then you feel that this works basically, and don't
What-
have concern with addressing the C or the staff comment?
Well, I think those are two different things.
Okay.
So I think what the staff comment is from LSO is who's deciding it meets the qualification of this statute. An individual employee, because we were applying this to employees,
Everyone, yeah.
everyone. So it comes into your local clerk of court, and that person, I think we have some assistance coming in from Ms. Hanson over here, but anyways, it comes in from the clerk of court gets it. Who's she going to, or who is he going to determine whether the foreign judgment meets the qualification of this statute? I'm not as worried about the staff comment because I think there's ways to deal with that. Most of our governmental entities have attorneys they can
Right.
talk to. But anyways,
Probably
we can
true.
hear from LSO.
Yeah. Talise.
Mr. Chairman, yep, the staff comment mostly arose from, I mean, not all speech is protected, right, under the First Amendment, and there are incidences where the government can limit speech or, true threats or defamation or incitement, which aren't necessarily protected. So if someone said something and an employee at an agency is not quite sure if that is speech that would be protected under the First Amendment or the Wyoming Constitution. It was just raising a concern that they might not know what to do. And I mean, if it's a governmental agency, they could probably go talk to the AG and ask, but it was just something for the committee to consider that it might not be very clear cut for the governmental agency or whoever to know that this would or would not, or most likely would or would not be protected under the First Amendment.
Yeah, I can see that. And again, going back to the plain language on page 5, it's state its political subdivisions and its employees acting within the scope of their official duties shall not. And so you get into a situation where there is an expressive action and there's a request to assist in the apprehension of an individual, then, I mean, it would go through their official scope of duties. And I think they probably would do what Senator Craigo was saying if they'd go to whatever attorneys or interpretive group they have, they'd have a conversation about it, and they would try and make that judgment. If they didn't feel that they had the capacity to make that judgment,
They might use AI.
they might use AI. Yeah, that's what they would do. And if it was an adverse event, then you'd have to have a human if we passed that other bill. I don't know. I honestly think, I feel like it works. I feel like it's going to work out because the employees would use their best effort to make that determination, get the best legal guidance they could, and then act accordingly. And if it doesn't go the way of the individual, then you have the declaratory relief clause. If it does go the way of the individual, it would go through the process that Senator Craigo said, where the foreign entity has the opportunity to appeal. Go ahead, Senator.
Mr. Chairman, one thing, when I read the comment, one thing I thought we could do, and I don't think it affects the bill, you know, in any sense, is on page 5, instead of using the term employees acting within the scope of their official duties, just limit it to except as required by federal law, the state and its political subdivisions shall not. And then you take the conversation about employees out, we still would give them the protections later on in the bill. But then it's, because that's a little bit some unique language there. It would still apply to the employees because they work for the state
Right.
and or the political subdivisions. Then I think that would address staff's concerns a little bit, because now we're not putting the onus on the employee to go track down a lawyer. They would anyways, but it doesn't look like it's their requirement to do. It's the state or the political subdivision's job. The employee just happens to work there.
I like that. Talise, your thoughts? Okay. Mr. Co-Chairman?
Sounds good to me. Mr.
Yeah,
Chairman.
I think that strengthens it. Okay. Do you have that, Talise? All right,
Mr. Chairman.
go ahead.
Yeah, Mr. Chairman, I think that will probably be the best way forward. If we want some additional protection for employees, we could put in, the part where it talks about good faith, that we presume that they're operating under good faith. So you have to prove the otherwise, that they're not operating under good faith.
Yeah, that's a good idea. And that was a question I kind of had related to it is, yeah, okay. Because I thought we talked about that a little bit. Where is it? Let's see. There we go. Page 8. No state. So the D paragraph, no state entity, political subdivision, or employee acting within the scope of the entity's political subdivisions or employees' official duties shall be subject to civil or criminal liability for any act or failure to act taken in good faith pursuant to or consistent with subsection C of this section. Okay, so we provide that protection and make it clear. Is that sufficient, Representative Yen, that language?
Yeah, so it doesn't make the assumption that it's in good faith, right? I don't know who that burden lies on deciding whether it is a good faith action or not. So if we automatically presume that it's in good faith by putting some additional clause or sentence, maybe that would provide some more protection.
Okay, yeah, go ahead, Senator Craigo.
Mr. Chairman, I'm not positive, and maybe Talise can look this up, but I think in Wyoming law, I think there's some case law regarding that it is presumed that your governmental employees are acting with good faith, but if not, we could easily put a sentence into that effect. But
Happy to wait until we find out more.
I think we could look that up between now and our next meeting and figure that out.
Okay. Let's do that. Then Talise, will you take a note on that paragraph and either we find out if that's presumed or if it's not presumed, we can just change the sentence construction such that it notes that it's made in good faith or assumed to be made in good faith, and then provide the exception, et cetera. So just kind of reversing that language. Okay. Then with that, let's go to the bottom of page 8, the next staff comment. And Talise, I'll let you explain the staff comment because you provide the context of your concerns there. So go ahead and.
Mr. Chairman, yep, the next staff comment was just more of a note for your consideration that, even though we're providing the protection in D, saying that we're not gonna be subject to civil or criminal liability, it doesn't mean that the employees or the state wouldn't have some sort of liability or be sued by the foreign state or whoever is trying to get us to cooperate or do the things that the employee's not doing. So it's just a note that this is providing protections for us that we're not going to subject them, but they still might be subject by the foreign state's laws or something else that we're refusing to cooperate with, like a subpoena or something like that. So it was more of just a note that you guys are aware of that.
Okay, good. One thing that comes to mind on that is the employees. I assume that there would be really no circumstance under which the individual employee would be, if they're acting in good faith, would be held accountable to external jurisdictions. It would be the state, I would hope. Is that accurate? I don't know that we would need to say anything, but we would definitely want to be protecting any of our people as a state instead of as an individual. Is there a concern there, Talise?
Mr. Chairman, I don't know if there's a specific concern, but if the state was getting sued by a foreign state, they would probably depose the employee who made that decision. So, I mean, I don't think there's a way to ensure that they wouldn't be subject to it. But yeah, it would be, they would be suing the state, but through that,
Right.
The employee would most likely still have to participate.
Yeah. Participation, I think, is fine. I just want to make sure that they're not somehow held to be liable on behalf of the state when acting in good faith. Go ahead, Senator Grego.
Mr. Chairman, it's going to depend who the lawyer is on the other side.
Right.
I mean, in all seriousness, there's nothing to prevent them from suing the employee, suing the state, suing the county. I mean, there might be multiple levels of defendants, and the employee is likely to be included, but the employee would get coverage, both legal and otherwise, most likely through their employer at that
Right.
point. But they might be a named party, and there's no way to
Well,
prevent that.
you know, that's an interesting point, though, because you say that, and it does ring a little bit of a bell for me because of the number of times I've been sued as a legislator, but in my own personal capacity, I've been added to the lawsuit. And then in each occasion, the AG has gotten me and the other legislators that were being sued removed from the case. So that's turned out just fine. But I can think of a circumstance where a state employee had to retain their own counsel because they were named in a fishing expedition case and the state AG didn't step up on their behalf. And therefore they, had whatever, $1,000 out of pocket to get removed that they ended up paying. That's probably a broader problem than this, but I wonder if there's a way we can remedy it and to make it very clear that the state shall represent the employee.
Mr. Chairman, I think we can write that right into
Yeah.
the bill, that if an individual employee gets sued while
Acting in good faith.
acting in good faith pursuant to this act, that they will be provided legal assistance
By the state. Okay.
by their employer. It might
Yeah.
not be the state.
Right, exactly, by their employer. Yep. Talise, did you get that concept to add? I'm not worried. I mean, if the state gets sued, that's fine. Things, it works through the courts and it's all okay. But individuals getting severed off like that, yeah, I was kind of offended by the one circumstance that came to mind. And I was actually shocked that it went that way. I was amazed that the state did not stand up for that employee and do the simple defense action that was needed to remove the employee. They had to do it themselves and pay out of pocket. So that probably shouldn't happen. All right, we're good there. Any further discussion? Go ahead, Senator.
Mr. Chairman, just wanted to clarify, and we don't have to decide this right now, but there is a difference between the state providing a defense at their cost and the employee picking who they want and the state providing, paying for that lawyer. So,
Absolutely.
and those are going to be two dramatically
Right.
different numbers.
Yeah.
Just because of how the system works.
No, definitely. I mean, in the case that I'm referring to, the AG bailed on the employee and the AG should have supported the employees. So it wasn't a desire by that employee to have better counsel. It was yeah, we don't think we're obligated to include you in our action. But I was included. I was on the same list, and they fortunately did go to bat for me.
Mr. Chairman,
Go
and I was just going to comment, it may or may not be better counsel, but it will be more expensive counsel. That I can guarantee.
That is a certainty. Okay. All right. I like that change. Mr. Co-Chairman, you comfortable with that?
Yes.
Yeah. Representative Yin, good? All right. Very good. Page 9, page 10, page 11. All right. So I think that's it for the comments that we have on this bill draft. Mr. Co-Chairman, any other discussion before we go to public comment at this point in time?
Nope.
All right, then let's do that. So we are on consideration of 27 also 9 version 5 protected expression limits on foreign judgments. We have the bill draft here. Is there any public comment in the room? Any public comment in the room? All right, come on up. Please introduce yourself to the committee, and the floor is yours. Yeah, there you go.
There we go.
Green light.
Thank you, Mr. Chairman, committee. My name is James Halverson with Americans for Prosperity. I don't have a whole lot to add. I just want to say thank you for the hard work on this. We've been supporters of the Granite Act throughout the years. Making this a little bit more palatable than the one that was brought last session is probably a good thing. That was a little bit tough to get through, obviously. So we appreciate the representative and the good work, and we think this is a great start going forward, and we'd love to be part of the process. So I don't have anything else. If there are any questions, I'm happy to take them.
Thank you. Any questions for Mr. Halverson? Any questions? Seeing none, thank you. Appreciate that. Any further public comment on 27 also 9 in the room? Seeing none, any online?
Mr. Chairman, we do have Mr. Maher online.
All right. Let's invite Brendan in to show himself. He's invisible right now and unhearable, so we might be going through our standard leave and rejoin. Let's find out.
He's been censored.
Yes, foreign governments have taken action against Mr. Brendan Maher. There, he's coming back. There he is. Oh, there he was. There he is. All right. We can
Hi,
hear you, Brendan.
Yes,
Please introduce yourself briefly, and the floor is yours.
Brendan Maher, MIT Media Laboratory alumnus, on various working groups for the committee. I'll be fairly short. I want to say, first off, I love this bill. This is just tremendous. It's great. I want to speak to loaves of bread because I think it's very important. What I see happening here is that this bill gets referenced. Hopefully, it gets passed, but it gets referenced in the Wyoming Digital Identifier Act, and this has some implications which I think are very interesting because that will specify differences between Wyoming Nexus and Wyoming Lexidus in terms of things that are pointed to. So to answer the question around this mysterious loaf of bread, I think was in North Korea. The question is, well, does that come under the act? And part of that comes to the issue of, what is the res? What is the thing pointed to? And is that property? Is it real property? Is it intangible property? Is it intangible property that's free speech? You kind of get where I'm going. So I think some of these things can be partially aided and resolved a bit as we move further along. That's really fundamentally what I wanted to say. I'll take questions.
Thank you, Brendan. Any questions for Mr. Maher? Any questions? Seeing none, thank you. Appreciate your testimony. One concept that brought to mind, Mr. Co-Chairman, was the idea of, we'll say, conspiracy or something along those lines, an expressive in nature, but criminal in content, at least from the jurisdiction perspective. I'm not entirely sure how that ends up getting handled. If you have someone visiting the United States and they say, I think we should overthrow the regime. That is clearly an expressive action. It's First Amendment protected speech in the United States, but it might be a clear criminal code violation in the source country. And it's hard to say at that point. So if we do the dividing aspect that we were talking about a little bit earlier, where we say, well, we're protecting the expressive act, but we're not protecting against an associated criminal action, and suggesting that the regime be overthrown is a criminal action, I'm not entirely sure where we end up on that. Like from the plain reading of the text, I don't know what I would then do. And this assumes that we make that clear change of we protect the speech. Go ahead.
So, Mr. Chairman, I mean, as I read the bill and you go to the definition on page 4 of protected expression, we have to analyze the elements of that particular offense / crime, whatever it is, in light of the U.S. Constitution.
Mhm.
So would that be a crime in the United States? If the answer is no, then it's protected by our First Amendment. If the answer is yes, then it is not, and we would have to essentially, levy the judgment, execute the search warrant, execute whatever we're talking about. But if it is protected in light of the First Amendment, then this bill would apply and
Mhm.
move on.
Okay.
I mean, that's
that
how
makes
I
sense.
read
Yeah,
it. I think
that sounds fair.
it's not going to be relevant on what the law is in whatever country we're talking about. Is what is the law here, and would that speech or would that action or speech be protected by our First Amendment? And so this goes to Talisa's point earlier about who's deciding. It does get complicated, and it could, and you may have to, which is okay, we have a provision to do this. You may have to get advice from the Attorney General's office, even if you're a county attorney,
Right.
such as myself, who's not, maybe well-versed in the First Amendment. You might have to get a First Amendment expert from the AG's office to help you make that decision.
Mm-hmm.
And we could also, maybe that's something to Lisa's point on the staff comment. Maybe that's something we think about at the next meeting. Maybe we put a provision in here that any governmental entity can request
From
advice
yeah.
from the Attorney General's office, because
Yeah.
right now they get overloaded with opinions off requests often, and this probably wouldn't be a priority unless we put into statute that it is. So something to think about.
Let's draft that. Let's actually have that written up so that we're ready for it next time and can discuss it. I think that's important, and that would be helpful. Okay. Good thought, Senator. Thank you. Any further public comment online? Okay. Seeing none, public comments closed. Back to the committee. Obviously, we're not going to take any action on it today, but is there any more discussion on this legislation? Any more changes? Anything we want for our next meeting? Go ahead, Senator.
Thank you, Mr. Chairman. I just wanted to say, this bill's in a much better spot than when we had seen it during session. I think we can actually execute the bill if it passes, puts our governmental entities in a good spot. They can use it to protect Wyomingites, Americans, et cetera, without having the issues that I saw in the previous version. So I'm excited where it looks now.
Excellent. Thank you, Senator. Further comments? Representative?
Mr. Chairman, I think looking through this bill, yes, it is a lot better than it was when we saw it during session. But two, in some ways it's analogous to the Second Amendment Protection Act amendments that we had.
Yeah.
Right? It's talking about how we as a state are not going to enforce, what could be a federal treaty obligation, because we believe in the First Amendment. Even if the federal government might try to enforce it themselves, we're not going to cooperate with that. And so, I think that's all right. And we can figure out where we draw the line, because it is a federalism issue of, what are the parts that we play as a state versus what parts does the federal government play? And frankly, our part should be enforcing the Constitution, whether it's our U.S. and state Constitution, and not to necessarily enforce treaty obligations that we played no part in as a state.
Agreed.
So
Well
I
said.
like it.
Thank you, Representative.
Mr. Chairman.
Go ahead, Senator.
Mr. Chairman, I'm not sure I agree wholeheartedly with that. And the reason being is this one's different than our bill that talked about the Second Amendment, because this one says except as required by federal law. And so it says that in all of the provisions, except as required by federal law, whereas the other bill we're talking about attempted to override federal law. And it did not say, it said notwithstanding federal law, not except as required by federal law. So this one actually carves out. So if there is a federal law that requires us to comply, we still have to comply. This is just talking about what happens in our state courts, and if a treaty applies, then a treaty applies. This won't override that. At least that's how I read it, but I could be wrong and usually am.
No, I think that's probably fairly accurate, but obviously, with the Second Amendment Protection Act, and Senator Case, I think during the floor speech, said he'd like all of the Constitution Protection Act, where we had only the obligation to uphold the Constitution. But I do agree with Senator Crago. This doesn't go quite that far and doesn't limit circumstances where there's a federal law or federal requirement that the state take action. And, maybe we'll go there someday, but probably not with this bill right now. Mr. Co-Chairman, do you have any thoughts?
Yeah, thank you, Mr. Chairman. And I am working on a Third Amendment Protection Act, but I've yet to unveil that. And so, but until that time, I'm just really grateful for the. Thank you, Mr. Chairman. I'm really grateful for the time that we put into it, and I look forward to the rest of these working meetings.
Yeah, no forced quartering. Thank you. You will not quarter. All right. Anything further on this? It seems like we're good. Talise, any further questions before I move on? All right. So what we'll do on this, and I think we'll either circulate to the working group or we'll have a working group meeting. We'll see whether we need judgment or whether everyone's just comfortable with it, but we'll get the amendments made that we just discussed and then circulate to make sure we're comfortable with those changes and have that ready for our September meeting. All right. Excellent. Okay, up next, Mr. Co-Chairman, is the right to use virtual private networks discussion. Now, this is just a discussion. We don't have a bill draft, but this is a topic that I think came across your radar and you wanted to put it into our personal data privacy and ownership topic discussion. So go ahead, Mr. Co-Chairman. What are your thoughts here?
Thank you, Mr. Chairman. And I just wanted to bring this to our attention, but we talked a lot yesterday about the benefits of some sort of a way to validate an identity digitally and the work that Utah is doing. And it is impressive, but on the flip side of that, we have also, if we were to adopt that type of policy, we would essentially make it impossible for someone to have a virtual private network, and one that could not be traced or attached to some sort of internet activity. And I just thinking about, the freedom of speech, of course, the ability to say something anonymously is really foundational to the way that we perceive political speech here in the United States. The Federalist Papers were published anonymously. And so the ability to remain anonymous is essential in the United States. And so with the technologies that we are embracing, we have the opportunity to enshrine in our statutes the ability to have a virtual private network. It's like a service that's being provided by a lot of different entities on the internet right now, but it creates an encrypted connection between your device and the internet, making it harder for others to see your online activity. It's like a secure tunnel. They're cybersecurity tools and they protect privacy, and it doesn't really make illegal activity legal. However, it does change the way that you encounter the internet from jurisdiction to jurisdiction. And so, for example, if you were in Wyoming and you go to your favorite media subscription provider. So let's use Netflix, for example. If you went to Netflix in Wyoming and you had what was available in Wyoming, if you used a VPN and you had it set to show that you were actually a user in the United Kingdom or in Nigeria or wherever you decide, you'll get served a different there will be different movies and TV shows that are available to you. And so I think as different states come up with different policies about what digital identity means and how the government interacts with people on the internet, I do believe that ability to remain anonymous and to interact with different forms of the internet without being specified to where you are in a geolocation type of a sense. I think that's something that we can preserve moving forward and something to be conscious of.
So, Mr. Co-Chairman, on the Utah digital identity, I really don't think the digital identity conflicts with VPN, but they did pass some amendments to their Online Age Verification Act that targeted VPNs. So I don't think there's any inconsistency with digital identity. We can do anything we want with digital identity and still support virtual private networks. They're going to work just fine. There's no problem there. But there is a concern with following this model, and other states are looking at it also. And we went down, we took a step down that, right? We passed an online age verification bill as well, where we require that independent third-party verification. Personally, I thought that was a lousy bill. I voted against that bill, but there wasn't a lot of opposition to that bill because the bill was about pornography, porn sites, largely. And so I think politically, nobody felt like they could vote against a bill that was in support of people having free access to porn sites. I think it was more political than anything else. But when you get down to it, what it is at that point is a requirement that you register with a third-party verifier that then knows that you're interacting with it and that you're obligated in Wyoming under certain circumstances. So you're basically circumventing your own individual freedom. The state of Wyoming enacted that, and that's in place at this point in time. But the step that Utah took, they went one step further, and they said they're going to target the VPNs so that if you use a VPN to access, that is a liability to the data provider. So the host of the material is obligated to know whether you're accessing it by VPN. So if it shows up that you're coming from New York or California or wherever else, but you're really from Wyoming, you're on the hook. Or you're really from Utah, I should say. You're still on the hook and you still have liability, which I don't even know how that's implementable, candidly. But that was the step that was taken that, again, passed by a wide margin for the same reason. When you're publicly saying bad things about pornography sites, you pretty much have to go along with that vote. But it still causes some concern if you're looking at it strictly from a privacy and individual rights, personal expression, First Amendment rights standpoint objectively, and take the topic off, but really just look at what the underlying law does. Is it requires an awkward amount of disclosure, and it targets and chills virtual private networks. A couple of other states looked at doing revisions also to virtual private networks, and there's been discussion of banning the use of VPNs. In some states, I don't think any bill has passed a full ban of VPNs, but it's an interesting question. And I think one of the things that Wyoming could do would be to kind of go quite the opposite direction, which would be to say we're protecting the use of virtual private networks and basically anonymity on the internet. that would be in direct conflict with the bill we passed. And that passed by a wide margin. So I honestly don't know if we could get that bill passed. I'm not sure whether we could. What are your thoughts? And committee, what are other thoughts? This is just a discussion piece on whether we should take any action on it. It's something I would certainly support, but I opposed the last bill.
Mr. Chairman.
Yeah.
Thank you, Mr. Chairman. So just something to consider, in order to solicit that service specifically, someone would have to use a credit card to gain access to a VPN anyways. Am I wrong about that? Representative Yin?
There
We have an
are
expert.
VPNs that accept both cryptocurrency and cash in the mail. And all you give them is a login number. You don't even have an account number or password. So you don't, I mean, there are VPNs who are explicitly trying to protect your privacy. And so you don't need, there are no KYC regulations around any of that.
So you can still be anonymous if you choose to. It just takes a little bit of extra work. But states are working against that anonymity. And for obvious reasons, right? Everybody wants to know what everyone else is doing. We know that. And we spend a lot of time doing that in the Wyoming legislature, we pass laws that allow us to know what other people are doing because it makes other things easier. With VPNs, that's one of the pushbacks for it, is it does allow a certain amount of anonymity. And it also allows circumvention of things that, as you said, geofencing of programming and content is a great example, right? If you want to watch a Bears game and you're in a blacked out zone where you can't get the Bears game, your VPN can get you the Bears game. So it's fairly common. Committee, Senator Crago, what are your thoughts? Is this something we want to tackle at this point in time? It's probably not a really difficult bill, but there's a lot of implications associated with anonymity and privacy.
Mr. Chairman, I have no idea. I mean, it might be very difficult to get past, number one. And so I don't know if we want to spend a lot of time and effort on something that we don't have a good sense of whether or not it's going to pass. But that would be my only 2 cents. I mean, I'm not opposed to it, the idea, and in particular, working the idea. I just don't know if that's something, as chairman, you want us to do, or if there's other things that we actually think we can accomplish and we could devote our time to that. I don't know, Mr. Chairman.
Yep, fair enough. Representative Yin, thoughts?
Yeah, Mr. Chairman, I actually don't know if I want to teach the legislature about VPNs. I think it is not ideal. I don't think the outcome that we will get will be the one that we necessarily want on this committee.
That's fair. Mr. Co-Chairman, thoughts? I mean, this is something, again, we have a lot of things on our radar that we can keep this on our radar and look for opportunities with it.
True. Yeah, that's thank you, Mr. Chairman. That is true. It would be almost as the Bears analogy would be almost as bad as intentionally planning a meeting during the England versus Argentina game.
Correct.
So
1-0 England.
there we go. If this topic is something that would be, we don't want to necessarily devote committee time to that for the pursuit of this idea. I can definitely respect that, and I would want to cooperate with my colleagues as best as possible. I do think it is important to talk about privacy on the internet, the ability to remain anonymous, and to seriously consider whether or not, if we passed a piece of legislation with good intentions, if the negative consequences of that directly contradict some of our core values. And I mean, we're still seeing how the legislation plays out with the age verification, but there are loopholes to the age verification bill that we passed already. You can use artificial intelligence to bypass the safeguards that we put in place in state law. And
You
kids
can use a search engine to
Yeah,
bypass it, honestly.
you can
It
use-
doesn't work.
Yeah, Mr. Chairman, you're correct. There's all sorts of loopholes, and so I don't think that we should be afraid of looking at those things critically. However, if perhaps it's better as a personal bill, then that's totally fine and that makes sense. So I'm comfortable with that as well.
That sounds good. And I mean, this is an important discussion. I don't know if there's we can take it public comment on it too before we move on to the next to see, but I think that's an appropriate direction for us to keep talking about it. Yeah, let's do some brief public comment here. Let's keep our statements brief, but I do want to hear from anybody here who has any thoughts on VPNs and what we might or might not want to do. Go ahead, please introduce yourself once again, even though we all know you.
My name is Dave Rowland. I'm in this case, Advanced Intelligent Networks Corporation. Two things on the a VPN, basically, just like you say, it's a secure tunnel. The issue is that an IP address typically has no validity, perhaps only for going backwards through the servers from like law enforcement. The issue in terms of whether it be protection of, for porn, that's where self-sovereign ID actually does come in. Zero knowledge proofs does provide the I'm over 21. And the issue is, that's one of the reasons to pass it through. It's also acknowledged in Europe to a point. So, the idea that says, well, we track 70,000 malicious agents across the planet, have been doing it for 10 years, millions of incidents. And one of the things about it is we get them, we filter out right now anybody who's outside of the US just for our, proof of anyway. So the idea that says we're going to see an IP address, we're getting hits from China that I know are coming through racks in Texas. So, there's no benefit outside of who's really at the other end. You can get a fingerprint depending on how it's done, but there's so many ways to set up a tunnel without going to a commercial service. So, that's the only thing you'd really say is if you want to keep them out of the porn, follow through on self-sovereign IDs, make sure that they have, proof of age, zero knowledge proofs. So.
Thank you. Appreciate the testimony.
Any questions?
Any questions? Seeing none. Thank you. All right. Anyone else in the room want to give any public testimony on this topic? VPNs? Seeing none. Anybody online with their hand up?
We have Mr. Maher, Mr. Chairman.
Mr. Maher, welcome back. What are your thoughts? He's frozen. Thoughts are frozen. Anyone else online? Okay. Give Brendan about 10 seconds. Or he's very, very still.
Yeah, he definitely wants to.
Oh, yeah. So he'll probably log right back in. Let's see. That's typically what he does. And there he is. Brendan, we see you this time. We probably can hear you. All right.
Great, thank you. Yep. For the record, Brendan Maher, MIT Media Laboratory alumnus, computer scientist. And I want to say, I concur with David Rowland, but I want to talk, I will be brief, but I want to talk about the opportunities on the radar here that you mentioned and how we can get around this VPN issue, and a little bit more regarding constructs that'll help you understand the problem and the issue. So, generally, yeah, sure, I'm for a bill like this, but I do agree with Representative Yin. It might be hard to pass, and this is how we can get around this, and this is exactly what I've been talking about, and also what David Rowland has been talking about, in terms of that there's these two different layers. So VPN fundamentally is an addressing screen. It is an addressing scheme based on addressing of HTTP or more specifically IP addresses. So it's based on IP addressing. Okay. Separately from that, let's look at an entirely different ecosystem that we understand very well in this committee, which is called distributed ledgers, right? Why do distributed ledgers work? Because from an operational standpoint, not in terms of how they're actually implemented, but how they functionally work, there are no IP addresses, right? There's at a low level there is in terms of like installing software and communications, but that's separate. But at the functional level, there's no IP addresses, which means that you can have ZKP type proofs and message sending independent of geofencing, right? So what David and I are both fundamentally getting at, and I'm sure he'll concur, is that there are ways to get around this issue with a careful architecture. And this is why I've been beating it over the I don't know what the word is, beating the drum on the fact that when we design the statutes, we need to have the pegging to the Wyoming Secretary of State entity database, and then separately on top of that, you would separate out the kinds of things related to verifiable credentials. So, there's certainly a way forward. I think we don't necessarily have to explicitly have a VPN act, but we certainly could, but we have to work through this a lot more. That's all I have to say. I hope it is helpful.
Thank you, Brendan. Appreciate it. Yes, it is. Any questions for Brendan? All right, seeing none. Thank you, Brendan. Any further online testimony on this topic? Okay, public comments closed on that. I think that is something we kind of keep looking at, working on. If it ends up being an individual bill, I do think it's fortunately a fairly straightforward bill draft that probably doesn't take an awful lot of work to draft, so that's fair. All right, up next, make sure I'm not skipping anything here. Up next, we have consideration of a bill draft 27 LSO 33, working draft 4, biometric data and license plate readers regulation. We'll have Talise come walk us through it in a moment. And while she's getting ready, you can give us a little bit of background, Mr. Co-Chairman, on this bill.
Thank you. Thank you, Mr. Chairman. And the reason this comes from a bill that I had brought last session. Unfortunately, we were not able to take it up on general file, but I do believe that it's important. A lot of it has to do with the camera systems that are showing up across the country. And I've been hearing from my constituents that they're upset about it. And so it is from that concern that I brought the initial bill. But it has to do with biometric data. So everything from your fingerprint to your eyeballs to just how a camera could perceive you. And then, all sorts of technology, how you could be recorded and measured, and that sort of thing, and that's outlined in the bill itself. But also with the use of license plate reading cameras, that your location could be tracked and indiscriminately used against you without the use of a warrant or any sort of judicial action to protect the privacy of someone. And so that is the intention of this bill. And I understand that there are pros and cons to the technology involved. And that really is one of the distinct privileges of this committee, Mr. Chairman, that we wrestle with new technology as it comes along, and we find where our rights exist and where the benefits to society for these new technologies exist. And we are the ones who, at the end of the day, get to have that voice and present to our colleagues how we want to move forward as a state when it comes to new technology. And so I think this is a prime example of how there are contrasts in our rights that are written in the Constitution and technology that is emerging. There can be benefits, and I believe that we can use the technology and protect our rights at the same time. And so I hope to accomplish that with this bill, and I look forward to the discussion.
Great, thank you. And with that, Talise, do you want to walk us through the bill?
Mr. Chairman, members of the committee, Talise Hanson, Legislative Attorney LSO, presenting Bill Draft 27 LSO 33, version 0.4, biometric data and license plate readers regulation. This bill was drafted at the request of the chairman and is a resurrective 2026 House Bill 181. So, Mr. Chairman, a mix of a high-level overview for you is this bill draft would prohibit governmental entities from obtaining, retaining, possessing, accessing, requesting, or using biometric data to identify a person or verify a person's identity, geolocation data to identify the specific location of a person or motor vehicle, or an automatic license plate reader system to identify a motor vehicle. Installing or equipping an automatic license plate reader system on public buildings or on public roads and highways in the state. Using an automatic license plate reader system to collect tolls, road usage charges, congestion fees, or any similar charges or fees imposed on public roads or highways in the state, or entering into an agreement with a third-party vendor to perform any of these activities previously listed. The bill draft would prohibit governmental entities from purchasing or subscribing to the data, sharing the data outside the governmental entity's jurisdiction, and selling or conveying the data to a private, non-governmental third party for any purpose. So then bill draft would create limited exceptions for law enforcement, including allowing the use of biometric data or geolocation data primarily for violent felony investigations, missing person cases, or emergencies, and would require a warrant and would prohibit the reliance on such data as the sole basis for probable cause. The bill draft would create limited exceptions for the use of automatic license plate reader systems for specific law enforcement purposes, such as stolen motor vehicles, missing persons, outstanding arrest warrants, and criminal investigations with warrant requirements, and would allow the use of the system for parking enforcement. The bill draft would create other limited exceptions for the use of automatic license plate reader systems by WYDOT and law enforcement agencies to identify motor vehicles at authorized locations, including at ports of entry, way stations, and commercial vehicle violations. The bill draft would require governmental entities that are allowed to obtain, retain, possess, access, request, or use this data to adopt written policies regarding the use of the data, and the bill draft outlines some minimum requirements for that written policy. The bill draft would establish a cause of action against a governmental entity and would exclude unlawfully obtained data from being admissible as evidence in any criminal or civil proceeding except to prove a violation of the chapter. There is a staff comment on page 7 that just highlights that the select committee may wish to consider whether this bill draft may have unintended consequences on certain current governmental practices and whether these practices are intended to be encompassed by, excluded from, or otherwise addressed in the bill draft. And it kind of lists a few of those practices, which I'm sure some people in the room will probably comment on further. And I'll stand for any questions.
Thank you. Any questions for Talise? Go ahead, Senator.
Thank you, Mr. Chairman. So just a question on obtaining biometric data, which would include fingerprints. So for example, if you want to be a 4-H volunteer, you have to go to we go to our sheriff's office to get our fingerprints done. Would this bill prevent the SO from even assisting in doing the fingerprint cards so that they can be sent in for verification that you're not likely to harm children?
Ms. Hanson?
Mr. Chairman, Senator Craigo, yes, I think it potentially would because the bill is pretty broad. In drafting the bill, we did look at a couple of the other states that had biometric data provisions or statutes, but this is kind of a new area, and so there was only 3 states, so it didn't quite encompass it. The direction that I received was to base this law off of Montana's law, which deals with facial recognition, but to expand it to include geolocation, automatic license plate readers, and biometric data. So Montana's law is more focused on facial recognition, and it requires a warrant for that, and it has limited exceptions. But this bill kind of took that general concept and expanded it. So I do think that, which is part of the staff comment, that there probably are some unintended consequences with the broadness of the bill draft for the committee to consider.
Was that Montana bill passed?
Mr. Chairman, yes, it is Montana statutes 44-15-101, 44-15-112, and I believe it was enacted in 2023.
Okay, thank you. Further questions for Ms. Hanson? Any further questions? Okay, seeing none. Thank you so much. All right, Mr. Co-Chairman, I know that we've got some public testimony on this and go to that in just a moment. Anything before we go to that? Go ahead.
Thank you, Mr. Chairman. I acknowledge that this may be kind of broad, and so we definitely have some work to do. But this is certainly something that, at least in my community, people are very concerned about, and specifically the use of the license plate cameras has been a huge concern. I know recently another municipality has taken action to prevent the use of these cameras. And so I'm interested in hearing the comments on this topic.
Great. Thank you so much. Go ahead, Representative Yen.
Mr. Chairman, thank you. We had a really bad accident on Teton Pass just this month. I think it was this month, from a truck that had its brakes fail going down the pass. So Teton Pass is very steep, going both uphill and downhill, but going back into the Wyoming side. And that truck killed 2 people and injured 1 significantly. There's a built-in scale in the road of Teton Pass, so we could automate weighing all of the vehicles that go across it, but we have no way to track what vehicle is the one that is overweight. So overweight vehicles go across that pass pretty much daily, and so without a method to enforce it, which we've had bills in the past that tried to put in a method to allow YDOT the ability to enforce that with technological means, we will continue to have accidents on that pass. And I totally understand the concerns. We have those same concerns in Jackson as well, right? So we have those cameras in Jackson in the town. And I hear those concerns from my folks as well. But I do think that we can't be overly broad here. I think that there are concerns that we should allow law enforcement the ability to keep people safe, but at the same time, protecting people's privacy and freedoms. And so trying to figure out how we balance that with this bill or other bills, I think is super important. I think this bill at the moment is a little too broad, but I do want to hear some testimony and seeing if there is a way forward with what we can do here. Thanks,
Yeah,
Mr. Chairman.
Thanks, Ian. And I think that's exactly what we need to look for. We understand clear and reasonable interests on both sides of this bill. And hopefully we can find a good place to land where we can go a long ways towards protecting individual privacy while ensuring that when there is an emergent need, like Representative Yen just outlined, that capacity is available also. So that's a good little challenge for us. All right, with that, let's go to public comment and let's start within the room. I know we've got several people on Zoom as well, but let's start in the room. Anyone like to address the committee related to biometric data and license plate readers regulations? Please come on up and fill the chairs. And as is always the case, turn the microphone on and then introduce yourself to the committee and proceed. Let's try and focus on 3 to 5 minute comments and then questions.
Thank you, Mr. Chairman. Taylor Rossetti, Deputy Director at YDOT. To my right, I have Lacey Bruckner, who is the Compliance and Investigation Manager on the non-law enforcement side of the house for me. And to her right then is Misty Zimmerman, who's the Driver Services Program Manager. I think a lot of what's already been said is very true. I think the broadness of the bill really brings us to bring forward just some thoughts that we have about, application and existing practices and how modernization of services may rely on some of these things that we're potentially trying to ban. I think the other thing that we saw as we were reading through this bill is that the biometric data and then the license plate reader things really do take us down different paths, almost to the extent that they may be slightly separate topics that might make them easier to address, one or the other versus both. But again, that's your guys' purview. But as we were really looking through it, we really in our heads were getting stuck where there was a little bit of overlap, but most of them were really down two separate paths as we were looking through it. The broadness of the bill and then the strict prohibitions being meshed together do bring some things to mind for us as we work through this. We do also support this group and the legislature's mission in trying to safeguard everybody's data and right and freedom to move about the country. But this does bring some concerns to us, even so far as the faith that this body has put into our driver's license and identification card as a valid credential to prove who you are to go vote. One of the most valuable things that you can use within the databases there is some of the facial recognition technology to ensure that I am who I say I am and that I am not voting somewhere else or even having multiple identifications within Wyoming. So facial recognition may play a role there and actually may solidify and strengthen the actual robustness of that credential within WYDOT. We do have multiple federal rules that we do follow. And this body back in 2020 actually passed a mobile driver's license bill that we've been working toward. And some of these biomarkers are actually things that would make that program more successful as we move forward. With that, sir, I'd certainly turn it over to Ms. Bruckner or Ms. Zimmerman, and they can provide you a little bit more detail that you guys really might be able to grasp.
Thank you. Who'd like to start?
Good afternoon, committee. My name is Misty Zimmerman. I'm the program manager for driver services. Just to add on a little bit to what Mr. Rossetti was mentioning, currently right now, WYDOT driver services uses a one-to-one facial recognition. What that does is that takes your previous photo and it compares it to the photo that's being taken that day. That ensures that you are that same person that was there. Ultimately, as a program, we would like to move to one-to-many, which if this bill were to pass in its current state, we would be prohibited from doing our current process, as well as one-to-many, which would then allow us to ensure that an individual is not receiving multiple credentials in this state under different names by providing false documentation. One of the other major concerns that we do see in this, that we do see as problematic is with our current online portal. Right now, our 1YO, which is the online portal for driver services transactions, requires a login.gov authentication, which login.gov does use biometric authentication in order for an individual to verify their identity. So as the bill is currently written, we would have to work with ETS to find a different way to work through that process. And then lastly, as we walked through our modernization project, which I'm sure you are tired of hearing about from me, one of the things on our current roadmap is mobile DL as well as teledriver services, which would allow mobile DL, obviously, we're all familiar with that MDL. Teledriver services would allow us to put computers in locations that we may not be able to access, and then do an on-demand verification with a person that would validate their identity to their photo through a text facial recognition, right? We'd send them an invitation, we'd do an FR on them, and then we could provide that service to a person who, on a computer that's sitting in a library in Matitsi, and so on and so forth. So we see some concerns on things that are on our roadmap based on this bill and what the biometric piece of it may do for us. The LPR data, I'll let Lacey go into some of that, but we potentially see some issues with the non-resident violator compact. If citations are done in another jurisdiction using LPRs, is that citation able to be added to the Wyoming driver record, things like that. So just fairly high level on that. We did do some research. Currently right now, AMVA did a survey in 2025 about jurisdictions using facial recognition or some type of biometric data. AMVA is the American Association of Motor Vehicle Administrators. 31 jurisdictions responded, and of that 27 used some type of biometric data for driver's license issuance, law enforcement, on-demand invitations, online portal access. So with that, I'll stand for any questions, and if none, I'll hand it off to Lacey.
Thank you, Ms. Zimmerman. Any questions? Any questions?
Mr. Chair.
Go ahead.
Thank you, Mr. Chairman. I do think that point that you made about another state if they were to use a license plate reader. That is something I hadn't thought about before. So thank you for bringing that up.
And on those points, we passed the government data privacy legislation last year, which basically says that you can't transfer or sell this data. And that's one of the things that actually is an underlying concern. And for the cameras that we're looking at in particular, government use actually still does freak out a lot of people. People are concerned about that. But to a lesser degree than all right, and now it's being sold to the private sector, and who knows what's going to happen with it. Just for clarity, right now, the biometric data that you use, you're not able to sell or transact that. That's being held as sensitive information, I assume.
Chairman Rothfuss, yes. So both motor vehicle and driver records fall under the Driver Privacy Protection Act, and there are limited things that an agency can do with those. And in fact, Wyoming takes that a step further and removes some of those authorized uses. So yes, a photo or any of those biometric data points would not be included in the information that let me rephrase that. The photo, the facial recognition or the biometric processes would not be included in any of that data that is allowable to be sold for whatever purpose.
Okay, that's helpful. Thank you. All right, Ms. Bruckner, welcome.
Thank you, Mr. Chairman, members of the committee. My name is Lacey Bruckner. I'm with YDOT Compliance and Investigation, and I'd like to speak with you a little bit about our department and motor vehicle services use of images that are obtained from LPRs used on tolling authorities in other jurisdictions, and how some of the language in this bill might affect our processes there. Motor Vehicle Services and Compliance and Investigation, we both use images from tolling authorities in other jurisdictions to investigate misuse of vehicle registrations issued in relation to YDOT business licenses. So our vehicle dealer licenses, our vehicle manufacturer licenses, our transporter certificates, all of those business licenses that the department issues, there are license plates specific to those businesses associated with that. There have been multiple instances where we have received LPR images from another tolling authority jurisdiction where we've identified misuse of those plates by those businesses that we license, and this may prohibit us from investigating those violations and taking administrative or criminal action against those licensees if we're prohibited from using the image to identify a motor vehicle. Another way in which Motor Vehicle Services uses images from LPRs from other tolling authorities in other jurisdictions is if that LPR image brings back data for a Wyoming resident whose registration that belongs to incorrectly. So if someone else goes through the toll bill and the wrong registration record is obtained by the tolling authority and they send the wrong person the bill, oftentimes hundreds of these a month probably, YDOT Motor Vehicle Services assists those residents in disputing those toll bills with the tolling jurisdiction. If we were not able to use the image from that LPR on that toll road, we would not be able to assist those residents of Wyoming in disputing their toll bill in another jurisdiction. So those are a couple of instances where our sections use images from LPRs regularly to assist residents in Wyoming from erroneous toll bills, and then of course to investigate some of the activities and use of license plates associated with business licenses that the department issues. Another thing that Motor Vehicle Services and Compliance Investigation work with together is licensing of vehicle dealers. One of the requirements for a new applicant for a vehicle dealer license is to undergo a criminal background check, which involves fingerprinting. So if the biometric piece of this legislation were to affect our ability to obtain those fingerprints and access the criminal justice information associated with it to determine if this applicant qualified for a license or had a record that prohibited them from having a dealer's license, we may not be able to do that either. And one other thing I'll briefly mention with the biometric data, along with what Ms. Zimmerman talked about with our driver's license system and using login.gov. A couple of years ago, the legislature passed the electronic lien and titling system legislation, which we are working very closely with a working group of industry stakeholders to modernize the processing and issuance of titles to do that, those processes, electronically as well. So one of the ways that we would be able to verify that this resident is the owner of this vehicle is through their driver's services credential, and their client account through that system would verify they are the owner of record on this vehicle and have a right to sell it or transfer it electronically through this system. Without the ability to use the biometrics necessary for them to grant them access to that system, we wouldn't be able to go forward with the electronic lien and titling system. Another piece of electronic lien and titling systems that this might be affect is odometer disclosures. Federal rule authorizes states to use electronic odometer disclosure statements as long as they're using the identification assurance level 2. That process does involve facial recognition. So you would use a selfie and they would compare that to the image you have on file with your driver's license to ensure that you are the rightful owner of the vehicle and you are authorized to disclose to the buyer, this is the odometer reading on this vehicle at the time I'm selling it to you. And then in turn, the buyer would also go through that facial recognition process, to log into that system and acknowledge that disclosure. I am the buyer and I acknowledge that the seller is telling me this is what the odometer reads on this vehicle at the time of the sale. Federal odometer disclosure law is there to prevent people from being victimized by odometer rollbacks. For every 10,000 miles you roll an odometer back, that increases the value of a vehicle $3,000 to $4,000. So it is a significant, I guess, in consumer protection. And that is something also that uses biometrics that may also be prohibited through this. And I think I've covered everything that we work with that this might address. And so for that, I would stand for any questions. Thank you.
Thank you, Ms. Bruckner. Any questions for Ms. Bruckner? Any questions? No. Appreciate your testimony. Appreciate you. Thank you, YDOT. All right. Again, in the room, please come forward and join us. Welcome. Please let us know who you are and tell us what you feel about this legislation.
Chairman, co-chairman, members of the committee. I'm Allison Moore. I'm one of the deputy directors at the Division of Criminal Investigations. Specifically, I'm over Criminal Justice Information Services. I'd like to explain to you a couple of things that this bill would impact, and then I'll turn it over to Commander Ryan Cox, who can talk a little bit more on our investigation side.
Great, go ahead.
Okay. Senator Crago kind of touched on this, background checks. We do a lot of background checks in Wyoming. They're all fingerprint-based background checks. Those are to vet backgrounds on various entities, educators, healthcare workers, daycare providers, foster parents, volunteers that work with children. Those fall under Wyoming Statute 7-19-201. There are also several other statutes that either allow or require background checks, fingerprint-based background checks. Almost every legislative session, new bills pass that authorize or require background checks be conducted on different groups of people. We also use fingerprints in our criminal history repository pursuant to Wyoming Statute 7-19-107. DCI maintains the statewide criminal history repository. This statute requires all law enforcement in Wyoming to submit fingerprint cards with arrest information when they arrest an individual. That information is critical to tie the arrest history and subsequently the disposition on that court case to the correct individual instead of a person who may come in and be able to use someone's name and date of birth. That repository is then used for vital purposes for public and law enforcement safety, as well as a fair legal process. Judges and prosecutors rely on complete records to determine appropriate bail, plea agreements, and sentencing. Employers, licensing boards, volunteer organizations rely on that complete data to ensure that the people that they're giving access to sensitive positions or vulnerable populations have passed a background check. Those backgrounds don't always rely solely on if the person has a violent felony. They often look for simple assaults, DUIs, theft, fraud. This information is also critical in determining firearm eligibility. Currently, we maintain those fingerprint cards indefinitely in Wyoming. Without fingerprints, we would need to rely on names and dates of birth. This means criminal records could easily be tied to the wrong person. Wyoming Statute 6-8-104 authorizes the Attorney General to issue concealed firearm permits, and we do that through DCI. Those concealed firearm permits require that an individual have a national fingerprint-based background check. Because of that, because of how thorough our background check is with the fingerprints, and because of how robust our criminal history repository is, CFP holders in Wyoming are able to enjoy reciprocity with 35 other states, as well as use their CFP to meet the requirements as a federal firearm background check. If we don't do fingerprint-based background checks, we will lose reciprocity with those 35 states. We will also no longer be able to use the CFP as a federal firearm background check, which will essentially shut down concealed firearm permits in Wyoming because you do not need a permit to carry concealed within Wyoming. Wyoming Statute 7-19-303 requires sheriff's offices and the Department of Corrections to submit fingerprints and palm prints to DCI within 3 days of registering a sex offender. DCI then in turn forwards those sex offender fingerprints and palm prints to the National Sex Offender Registry. These fingerprints are collected after conviction. They're collected at the time of registration, so they would not be part of a violent felony investigation. Failure to collect fingerprints and palm prints would violate existing state statute, but would also violate the Federal Sex Offender Registration and Notification Act, or SORNA. If we fail to comply with SORNA, not only do we jeopardize several grants that the state of Wyoming receives, but also we put the public safety at risk. And the FBI's National Crime Information Center, NCIC, and Next Generation Identification, or NGI systems are what law enforcement use to check for warrants, stolen vehicles, criminal histories, and missing persons, to name just a few things. In order to maintain access to NCIC, all agencies, law enforcement agencies, are required to have all staff members, sworn law enforcement, dispatchers, IT, any personnel who have unescorted access to unencrypted criminal justice information to have a national fingerprint-based background check. Failure to do those background checks would result in Wyoming losing access to NCIC. If we lose access to NCIC, law enforcement pulls someone over on the side of the road, they have no idea who they're having contact with. That person could be wanted for murder in another state. We also lose the ability to enter information to share with other states, such as that a person has gone missing in Wyoming. Failure to maintain these systems and functions within DCI poses a huge safety risk and jeopardizes citizens as well as law enforcement nationwide, not just Wyoming, because of that NCIC piece. And with that, I'll stand for any questions.
Thank you so much for that testimony, Ms. Moore. Any questions for Ms. Moore? Questions? All right. Seeing none, thank you so much. Mr. Cox, welcome.
Hello, my name is Ryan Cox. I'm sorry, Mr. Chairman, Co-Chair, Board. My name is Ryan Cox. I'm a commander with the Wyoming Division of Criminal Investigation. I'm in the operations section, or the gun-toting section of our agency. Today, while I recognize and respect the legislators' intent to protect personal privacy, the sweeping restrictions proposed in this draft present insurmountable roadblocks to active law enforcement operations. I intend to present some real-world operation gridlocks this bill would create, contrasted with some landmark Wyoming investigations. I'll first talk about biometric data, addressing deceased persons and identification through warrants. As the supervisor of the cold case unit, this one caught my attention. The bill prohibits governmental entities from using biometric data such as fingerprints or biometric photographs to identify a person or verify identity without a prior search warrant. This creates a legal roadblock when dealing with natural disasters such as a tornado or a flood, or accidental deaths such as a drowning or a car crash, or suicides or other non-criminal deaths. These are not criminal events, and we would be unable to obtain a warrant for a non-criminal event. Next, I'll talk about our ICAC unit, our child sexual abuse material that we investigate, also referred to as CSAM, and the databases that those are stored in. As drafted, the House bill likely unintended operation hurdles for Wyoming ICAC task forces. It's unintended operational hurdles for us. Under section 930-103, law enforcement agencies are strictly prohibited from obtaining, retaining, or using biometric data unless they are actively investigating a violent felony. While sexual abuse of a minor and the images that are associated with those are horrific, high-level felonies under this in Wyoming law, they do not meet the narrow statutory definition of a violent felony. Section 930-101 defines biometric data to include data derived from digital photographs subjected to automated algorithms or facial recognition outputs to identify a person. Because ICAC investigators must routinely analyze CSAM images using advanced automated algorithms, hash matching, and AI tools, frequently cross-referencing these files with the National Center for Missing and Exploited Children to identify victims or perpetrators. This language effectively prohibits standard investigative workflow. It would leave investigators vulnerable to civil suits and the absence of that ability to introduce that evidence in court. We also use these methods so our investigators in ICAC have lesser exposure to the horrific images that they see. So in doing so with this bill, we would be reversing time and we'd be exposing our investigators to more harsh images on a daily basis. The bill also creates a deeper legal paradox regarding evidence retention and collaborative data sharing. Wyoming ICAC must retain local copies of submitted CSAM images to validate and substantiate what was sent to NCMEC, even after Wyoming criminal cases are closed. Hence, there is no active investigation anymore. However, section 930-102 explicitly bars agencies from sharing biometric data outside their jurisdiction without a warrant, and section 930-105 imposes a strict maximum data retention period of just 7 days for data not explicitly tied to an active criminal investigation. Because the bill requires automated systems running facial or behavioral analysis to be treated as biometric processing, an ICAC database holding these images for long-term victim identification would violate the statute. I'd also like to address just artificial intelligence and how that plays into CSAM investigations. And essentially, I would just like to say that is quickly unfolding. And as I review the bill, I can see how it would have effect on that AI generated images, but those are yet to be determined as that is new technology that is out there. Bringing our attention back to fingerprints, I want to focus on the traditional crime scene processing method of collecting latent fingerprints, such as a burglary. As known, that is not a violent felony in the state of Wyoming, so we would not be able to collect those fingerprints at a burglary scene, and not even be able to apply for a search warrant to collect those fingerprints at a burglary scene. And ultimately, when the burglary suspect was arrested, again, a nonviolent felon, we wouldn't be able to collect his fingerprints to compare to the prints that we didn't collect at the crime scene. Just quickly, I'll just, in respect of time, I'll just touch on our state-issued devices. Technically, our state-issued devices are ever more collecting our fingerprints and our images, facial recognition. That's how I get into my phone. And as you see on your computers recently, you'll see a lot of information about passkeys that are being presented. And those passkeys are often subject to facial recognition to enter into your computer. And it is the computer that's actually storing that information. So technically, this statute would violate that. Next, I'd like to talk about geolocation data on specifically GPS vehicle trackers. Under standard constitutional compliant practices affirmed by the U.S. Supreme Court in United States versus Jones, law enforcement officers in Wyoming regularly apply for and secure search warrants based on probable cause to install live GPS tracking devices on vehicles belonging to suspected narcotics traffickers. However, Section 93103AI of this bill explicitly limits law enforcement's use of geolocation data to the investigation of violent felonies. Because high-level drug trafficking, including the distribution of mass quantities of deadly fentanyl, methamphetamine, and heroin, is legally classified as nonviolent property or narcotics violations, investigators would be structurally prohibited from obtaining a GPS vehicle tracking warrant for a drug suspect. I should also note, DCI does not shy away from writing warrants. In fiscal year 2026, our operations section wrote and obtained 808 warrants. That's a 54% increase in the last 3 years, and I'm sure it'd be a 54% at least increase from the previous 3 years before that. We continually write more and more warrants, and that is not of a concern. That is a point that we do use judicial process in many of the investigations, most every investigation that we do. Of those warrants, 60 were primarily pertained to geolocation data, and most all the warrants addressed geolocation data in some part. I'd like to talk about just sharing of information and not siloing off in law enforcement. Section 930-102B2 establishes a strict statutory barrier blocking local, regional, and federal cooperation. Wyoming law enforcement agencies are entirely prohibited from sharing geolocation coordinates, digital mapping timelines, or geotagged photographs with any agency or entity outside their own, except pursuant to a search warrant. This effectively outlaws real-time data sharing with adjacent law enforcement partners during fluid multi-jurisdictional operations. The proposed sharing wall also conflicts with DCI statutory mandate under 91627. I would also like to come back to our ICAC section and talk about cyber tips. I will share with you that all ICAC cyber tips are sent to Wyoming with geolocation metadata attached to it. That's how we determine jurisdiction. Additionally, when separate from our ICAC, just in any general investigation, when an agent would photograph a suspect using their state-issued cell phone, or when a citizen would share photographs of a criminal event, or when digital forensic tools dump a device or the data from a device, those most often have embedded GPS coordinates. And so us at DCI could not share with Casper PD a photograph that we took of the suspect if we were helping them out in an investigation that wasn't, especially in an investigation that was not ours, yet we had been given a bolo to watch out for a subject. Finally, I'll touch on automated license plate readers. I would first like to dispel some rumors and note some facts about LPRs. LPRs significantly boost police efficiency, with industry data reporting that the technology plays a role in resolving roughly 10% of all reported U.S. crimes. That's 700,000 crimes annually, boosting per officer crime clearance rates by 9.1%. Independent studies show that LPR-equipped patrol cars are 2 to 3 times more likely to recover stolen vehicles. It needs to be noted, though, also that there's no officers or personnel that are monitoring LPR logs. Instead, it is a passive system that only alerts law enforcement if a plate matches a preloaded hot list. Otherwise, data is logged silently in the background, accessible only retroactively by detectives with a case number and a justified reason, creating a strict digital audit trail that prevents arbitrary browsing. I will touch on 930-102, which places a blanket prohibition on installing or equipping automated license plate reader systems on public buildings, roadways, or highways within the state, essentially creating a large amount of blind spots if we were to use license plate readers. I would indulge in just a little bit more time. I will skip over some other situations, but I would like to just bring this home with an actual real life case from Wyoming. Actually, I have several, but I will bring your attention to this one. In a recent high stakes investigation involving members of the transnational criminal organization Tren de Aragua, TDA, underscores the vital necessity of real-time license plate reader data systems and instantaneous interstate communications. A cell of TDA operators traveled into Wyoming, executing a sophisticated, highly coordinated financial heist that successfully stole hundreds of thousands of dollars from local banking institutions via ATM jackpotting and fraud syndication. This was not a violent felony. Within mere hours of the incident being discovered and reported, Wyoming investigators utilized automated LPR highway camera networks to isolate the suspect's getaway vehicles. The system actively tracked the vehicles fleeing across the region state lines, showing them traveling towards Denver, Colorado, and Chicago, Illinois. Wyoming agencies instantly relayed the real-time LPR tracking intelligence across state lines to assisting agencies. This rapid interstate communication resulted in the immediate apprehension of 2 of the 5 primary suspects by out-of-state field offices and allowed the FBI to immediately establish active electronic surveillance on the remaining outstanding parties. Having automated LPR data readily available prevented Wyoming law enforcement from expending massive, futile local resources hunting for suspects who had already left the state, optimizing regional enforcement, and successfully breaking up a transnational cartel cell. The proposed bill would completely immunize these transnational networks like TDA against this type of Wyoming investigation. First, because the bank theft, ATM and fraud, and financial conspiracy are legally classified as nonviolent property crimes. Also, under Section 930-104A, judges would be legally prohibited from issuing an LPR warrant because the crime does not meet the strict violent felony threshold. Second, the moment Wyoming DCI agents phoned, texted, or emailed the real-time LPR tracking hits to the Denver Police Department or the Chicago FBI, field teams without a physical warrant in hand, those agents would have committed a violation of the statute. And with that, I'll conclude and stand for any questions.
Thank you, Mr. Cox. Any questions? Any questions? All right. I have one, just getting to the LPR data. You said that it's automated, which I understand, and that it's not directly accessed unless there's some sort of a ping. What happens to that data, though? And well, I guess 2 questions. First, do you own that data? Because I suspect law enforcement doesn't own the data most of the time, but maybe they do. Who owns that data?
Well, let me be clear about that. The state or Division of Criminal Investigation does not actually own any LPR cameras. So you are getting into a subject matter that I'm not completely familiar with, and I venture to say I don't know who exactly owns that data because we've never purchased such a product. We do have access to some different systems, so I can speak to that, but to that specific question, I don't believe I can answer.
For the systems that you use, who owns the data that's collected by those systems?
One of the systems is a DEA system. I would assume, I'm pretty confident that they own that system. To address your other question, I know, I don't know the time of the purge, but I do know that they purge data out of that system. You know, the other systems that we have access to are really, we contact a police officer in that jurisdiction that's responsible for the cameras. And if they have data, they provide it. So I don't have the great details.
I think
needed.
one of the concerns is the fact that a lot of it's private commercial entities that are selling the information through subscription, but then have access to that information for as long as they want. And I know that that's part of the concern from the privacy standpoint. And I was just checking to see if that was something that Wyoming was experiencing. And it sounds like we're not necessarily engaging with a third-party vendor and they end up with that information that they can do what they want with it.
Mr. Co-Chair, the systems that I have access to tend to be more of the government-owned systems.
Okay, and the data is held by the government or contracted, but on a government contract, it's assuming that it's in the cloud or something like that. So it's not sellable.
Mr. Chairman, Co-Chair, to my understanding, it's not being sold.
Okay, thank you for that. Appreciate it. Any further questions for Mr. Cox? All right, thank you, Mr. Cox. Do we have any more public testimony in the room? All right, come on up. And I'll note, yeah, both of you, please come up. I'll note that we're running low on time, and we've certainly heard a lot of comments. So let's try and get to around 2 minutes and be constructive in addition, because I think a lot of your comments will be similar to those that we heard. So please welcome and introduce yourself once again. We appreciate having you here.
Thank you, Mr. Chairman. I think the train's here.
There we go. The train has arrived.
Right. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. We do also have our WASCOP president on virtually today, Chief Travis Coltoscat out of Sheridan. I just wanted to mention, we heard a lot of testimony today on several different factors of this bill. Biodata, geodata, and LPR data are very different sources, and the combination of all three of those into one bill, I think, exacerbates the issue that we have before us and limits our ability to tackle each topic and come to a consensus. So I just would suggest that maybe the committee look at the possibility of 2 to 3 different bills to cover this topic. And you know, the way the bill is written, there's that exception for DNA in there. I would ask the committee to consider exempting fingerprints in the bill, as the testimony we heard before. Fingerprint is the primary source of state and federal government identification processes and touches upon multitudes of different statutes. Do want to mention briefly that in addition to the Montana law that we'd heard, Idaho does have one, Iowa has one regarding LPRs. And so there is some places that we can take a look at, and not only that, but case law. You know, we have the Supreme Court just this summer, the Supreme Court of the United States just this summer ruled on Chatry v. United States that geofence warrants, you know, are a search. So that case was remanded back to the lower courts to determine if the specific search was reasonable. So there are due process availability out there. We just need to tie it into it. When you're looking at LPRs and vehicles on a highway, we have over 100 years of existing case law to build upon. But with geofencing and or geodata and biodata, it's relatively new. It's going to take some time to get that balance in sync with the expectations of the public and so forth. The one thing that is a big concern in the language in the bill is that the bill prohibits the installation of LPRs on public right-of-way or buildings, yet gives exemptions for usage later on. If we can't put the LPRs out there, then we can't ever get to that point where we can use due process to get the data. And then also I would mention that in Wyoming, one of the exceptions to this would be if, like owner permission or stolen vehicle usage of the LPR. That could be a low level, that could be a misdemeanor. If it's a $500 vehicle or $800 vehicle, that's a misdemeanor crime.
I've driven one of those, yeah.
And but that doesn't consider crimes, other low level. I mean, they're not say low level, but low misdemeanors like stalking, domestic violence, battery, or even the felonies that we heard earlier with burglary. So, and the question about I think who owns the system and the data is a very important question that I think we can get to the bottom of. And I think that's something that law enforcement can be in a position to require action based on contracts with these third-party vendors. No, a local police department is not going to develop their own LPR system. However, if these companies want to do business in Wyoming, they're going to have to probably comply with some of those requirements that I think we can get through. And I'd be happy to answer any questions if you have any, sir.
Thank you, Mr. Thompson. Any questions? Go ahead, Representative.
Mr. Chairman, Mr. Thompson, I had a conversation with my chief of police about our flock contract agreement, and she was saying that we have one that's pretty unique. And she basically said that it is one that they don't have anywhere else in the country with regards of how they can use the images collected from the cameras in Jackson versus while they still have access to the images from cameras in other places. So I think that'd be something that I'm interested in seeing what those policies are put in place with that contract agreement. And maybe those could be guidelines that could be sufficient that we could implement with all of the agreements that are put in place across the state.
Mr. Thompson, any thoughts?
Just to add on to that, Mr. Chairman, looking at, the state of Iowa state law requires proactive ordinance allowing the uses on the local level. So there's that extra level of community involvement and I think, the example that we just saw in the news recently in Wyoming, there was some pushback on the local level and that changed a council's decision. In addition to that could also inform on the contract language and so forth. So,
and that was Iowa?
Iowa's law does that, yes.
That's helpful. And, I think everyone can see both sides of this. The side we're concerned about is not the side that's really being presented from an appropriate use standpoint. It's the fact that these third-party companies can, assuming the contract allows it, which a lot of the time they probably do, just archive all of this information and basically know my whereabouts with 125 data points that could be sold to a marketing company or to someone else that's data mining interest about me. That's a great business model. Sell it to you as the law enforcement and then sell that data for whatever other use I can sell it for. And it's amazing what data is packaged and marketed at this point, and a tremendous amount of money is being made off of that data. And I think this is one of the spaces where it's pretty Wild West on how they use that data. We don't have any control or say. I think our law enforcement is using it with the best of intentions, not intending to stockpile it, archive it, and use it for any of these intentions. But the companies that you're subscribing to, they're looking for ways to monetize the data set. That's their objective. That is their mission. Your mission is to serve and protect. Their mission is to make money off data. And there's our challenge. So,
Mr. Chairman,
any thoughts?
I think that might be why some of them might offer that very cheap service to law enforcement, because they're not making the money.
I bet it's a great deal. If you're not, you're either the customer or you're the product. Thank you. Any further questions, Mr. Thompson?
Mr. Chairman, if I could just add that WASCOP is more than willing to continue to work toward a solution that benefits the public of Wyoming and helps us fight crime.
Thank you. We appreciate that. That's helpful. All right.
Mr.
Go ahead.
Chairman, James Halverson again with Americans for Prosperity here in Wyoming. My kudos to the previous speaker. You know, perhaps there is a way to section out some of the things in this bill, but in general, we like it. We think broad protections are a good thing here in America. We don't want to live in an authoritarian society, which we see in some other foreign countries. Get permission or get a warrant. I mean, it's pretty simple. Or we carve out the certain exemptions, and those are in here for the law enforcement. Pages 10, 11 there's all kinds of them there. There are exemptions for finding a deceased body or a probable deceased person. There are exemptions for the DOT on way stations and ports of entry. There's all kinds of, and perhaps we need to carve out some more. We can appreciate that. I don't think anyone here is trying to say that we shouldn't do background checks or use fingerprints like we've done for 100 years. That's certainly not our stance, and we would be in favor of carving some of those things out, or the use of photos. But the use of biometrics, the use of facial recognition, the use of recognition of how I walk, my car, my license plate, I think those things need to be protected. We don't want this to be the Wild West, and we don't want all that data being stored. And to your point, Senator Rothfuss, whether that's government or third party, we don't think that should be stored unless it needs to be. And so with that, I'll stand for questions.
Thank you, Mr. Halverson. Any questions? Go ahead, Senator Craigo.
Thank you, Mr. Chairman. Mr. Halverson, thanks for coming. So quick question, because as I mean, and in Wyoming in particular, I mean, we heard testimony from our law enforcement folks. We really don't have these systems set up. We're either getting the data from the feds, or we may possibly be getting it from third parties. And I guess I'd like your thoughts on how do we deal with those two entities or groups of entities? Because this bill doesn't really address either of those. I mean, this is talking about state government and local government. It's not talking about really the feds, and it's not talking about third parties. And so what would be your proposal to deal with that? Because to be honest, I think that's the bigger issue is, and as the chairman has talked about, there's an opportunity for them to make money. There's no regulation whatsoever. That personal data can be stored by them, and it is being stored by them with no regulations whatsoever, whether we purchase it as the state or not. So thoughts on that?
Mr. Halverson, go ahead.
Thank you for the question. And I appreciate that. You know, again, I think that's probably another piece of legislation that should come forward. But at the same time, I don't know that we want to help perpetuate that third party's business by continuing to go down this path. Nobody here wants to infringe upon the law enforcement's ability to use those. There are exemptions in here for active investigations and warrants and all those types of things. So they can still do that. They're doing that now, and there's nothing in here that's going to prevent that. Moving forward, how we prevent that third party from doing that, I think that's a great discussion that needs to be had. I think that's an entirely separate piece of legislation. It may mirror this, but it definitely needs to look at that, whether or not we can continue to do that. I mean, part of that's back to the previous discussions earlier today. We've talked about that in this committee. The technology is coming very, very fast, and we need to stay on top of it. So my proposal on that is to just keep working forward, get a working group, I think they're coming for me already just because I'm opposed to.
There's your rod.
Yep, but they must have my data. I don't know. But yeah, I think those are great questions that we just need to continue to work together on.
Thank you, Mr. Halverson. Follow up? Good. Any further? All right. Seeing none. Thank you, Mr. Halverson. Appreciate it. Anyone else in the room at this time? All right. Seeing none, let's go online. I believe we have Lieutenant Colonel Germain up there. Or nope, we've got Mr. Koltiska up there, or Chief Koltiska up there first. Go ahead. Welcome, Chief.
Good afternoon, Chairman, Co-Chair, and members of the committee. Can you hear me okay?
We can.
All right. I will be very brief. As stated, my name is Travis Koltiska. I am the Chief of the Sheridan Wyoming Police Department and current President of the Wyoming Association of Sheriffs and Chiefs of Police. I will be brief because many of the things I was going to cover today have already been discussed by other public comment. But I do want to specifically address some of the bill's, my concerns with the bill's repeated limitations on investigative tools for law enforcement, particularly when it pertains to violent felonies. While violent crime deserves special attention, many offenses that Wyoming citizens would consider serious threats to public safety are not classified as violent felonies. Stalking, domestic battery, protection order violations, burglary, drug trafficking, financial exploitation, fraud, and identity theft are examples of crimes that can have devastating impacts on victims. Under this bill, investigators would be prohibited from using valuable evidence to solve crimes and potentially prevent violent felonies. I'm particularly talking about stalking investigations. Under current law, investigators may obtain search warrants and use geolocation information to corroborate a victim's account and establish a pattern of conduct. That evidence can be critical in stopping dangerous behavior before it escalates to violence. Under this proposal, that evidence may no longer be available because stalking is not a violent felony. The result could be fewer opportunities to intervene before someone becomes a victim of a much more serious crime. The bill's emergency exception also creates practical concerns, permits access to geolocation information only when there's an imminent threat of serious physical harm. While that language may sound reasonable, it creates circular problems for the investigators. In many cases, we seek geolocation information precisely because we do not know whether someone is in danger at the time. Another concern is the practical reality of criminal investigations. Officers responding to crime scenes do not always know immediately what we're dealing with. We don't know if it's a misdemeanor, a felony, or whether a crime has occurred at all. Investigations are designed to gather facts and evidence so that determination can be made. Some cases initially appear minor and later develop into major felony investigations. Other cases move the opposite direction. This bill creates uncertainty about whether evidence can be collected and exposes agencies to potential liability for decisions made before all the facts are known. I would also note that the staff comments contained within the draft raise several of the same concerns. The comments recognizing that limiting these tools to violent felonies may be too restrictive. They also acknowledge concerns regarding fingerprint evidence, which is specifically included within the bill's definition of biometric data. Fingerprint identification has long been recognized as one of the most reliable forms of evidence available to law enforcement. The draft further raises concerns about impacts to emergency response systems that rely upon geolocation information to locate people in need of assistance. Finally, the proposed 7-day retention requirement requires additional challenges. Crimes frequently are reported days or weeks after they occur. Multi-jurisdictional investigations often take months to develop. Valuable information that could identify suspects, locate missing persons, or connect related criminal activity may be permanently deleted before investigators even know it's available. Members of the committee, law enforcement agencies do not want to surveil people. We want to protect people. We want to find missing persons, rescue victims, identify offenders, and solve serious crimes while respecting constitutional rights and the privacy of our citizens. Existing legal standards already provide substantial protections and judicial oversight. This bill risks removing effective investigative tools without providing a meaningful public safety benefit. I respectfully ask the committee to carefully consider the unintended consequences of this legislation and the impacts it may have on victims, public safety, and the ability of Wyoming law enforcement agencies to fulfill their mission. Thank you, and I'd be happy to stand for any questions.
Thank you, Chief Koltiska. Any questions? Any questions? Seeing none, thank you. We appreciate your testimony. Thanks for joining us today. All right, Clarissa, who do we have next?
Mr. Chairman, we have Devin Brubaker next.
All right, let's bring on Devin.
Good afternoon, Mr. Chairman and committee members. My name is Devin Brubaker, representing the Wyoming Airports Coalition. I also serve as the airport director for the Southwest Wyoming Regional Airport in Rock Springs. Appreciate all the discussion today. Wyoming airports have a few concerns with this legislation, and I have emailed the committee a document that outlines some of those concerns, and I'll be very brief in summarizing those. First of all, airports, there's 3 airports in the state of Wyoming that are currently charging for parking at our airports, and whether you agree with that or not, the technology used to collect parking and allow for smooth processing of transactions oftentimes relies on license plate reader technology. And in the document I emailed to you, it outlines some of those details of how that LPR technology is used. It is not tied into any of those systems that we see on the daily news cycle of concern that I think this bill is trying to address. And the bill does attempt to provide a waiver, if you will, or an exception for parking facilities, but we don't believe it goes far enough. So we have some recommended language there. Airports are also required by federal law to adjudicate criminal history records checks, as well as security threat assessments and no-fly list participation, if you will, utilizing biometric data to comply with Department of Homeland Security requirements. And furthermore, airports are starting to see more and more of a trend of utilizing biometric access control systems instead of the typical badging systems that you see at airports. So we once again have some language recommended to amend to take care of that. And then finally, Mr. Chairman, well, not finally, I have two more real quick for you. We have some concerns about the 7-day data retention, and there's a staff comment that speaks to that as well. Oftentimes we have credit card chargebacks, we have requirements to keep records for TSA, we have lost ticket claims, we have a whole host of things that happen at airports, whether it's related to parking or TSA compliance, DHS compliance. And so we do have, once again, an amendment recommended for that. And then finally, some of our airports do utilize vendors to provide parking control, and we also utilize vendors to transmit the biometric data to the Department of Homeland Security. There is not a direct link to communicate with the Department of Homeland Security for airports. We need to utilize vendors to transmit that data. And so once again, we have an amendment recommended in the documents that I emailed out to you guys for that. So in interest of time, happy to answer any questions, Mr. Chairman. It sounds like this bill's got quite a bit of work to do. Wyoming airports are committed to working with you. And with that, I'd be happy to answer any questions.
Thank you, Mr. Brubaker. Any questions? Any questions? Seeing none, thank you. We appreciate your testimony.
Thank you.
Clarissa, next.
Mr. Chairman, I don't see anyone else with their hand raised at the
All right.
time.
Excellent. Thank you so much. Any further public testimony in the room? Seeing none, public testimony is closed. Mr. Chairman, on this legislation, obviously, there's a lot of concerns, a lot of work to do. We can spend some time now talking about it or philosophize later about talking about what we would want to do as a path forward. I was certainly persuaded by the fact that having 3 different topics in one bill really makes life difficult and makes it challenging to focus on solving the problems of any of them. So I'm certainly inclined to think that if we move forward, we would want to isolate the 3 topics.
Mr. Chairman.
Go ahead.
Yeah, Mr. Chairman, I'm starting to appreciate that as well. I think we're actually holding in our hand like 4 or 5 different bills, and so we may need to really divide and conquer when it comes to this proposed legislation.
All right. Well, let's give some thought to, and let me have you guys weigh in as well. Representative Yin, anything you'd want to prioritize from the 5 or so bills that are put together into this one bill?
Yeah,
what to do, what not to do?
Mr. Chairman, I think in my opinion, we should drop the biometric data part completely for this year and focus on the license plate reader.
Yeah, that my inclination would just be try and get something useful in LPR that doesn't break everything. Is everyone comfortable with that? Sure. Yeah. Okay. And so we'll have a substantial amount of work. We took a lot of feedback on concerns. We certainly have opportunity to work with WASCOP and others to try to find a bill draft that is effective for LPR and that addresses the key concerns that we're hearing from constituents. And so before next meeting, we'll try and put something together based on the feedback and bring a leaner LPR bill. Does that sound good, Mr. Chairman?
Mr. Chairman, that does sound good. I still am concerned about the biometric data.
Yeah.
And there's all sorts of different biometric data that even in the bill that there are all sorts of things that aren't described in the bill. And so I do
Agreed.
think that we need to look at those things, as well as another issue that I would like to address, and I don't know if that would be included in the LPR bill, but the use of a third party to somehow bypass the acquisition of a warrant.
I think the heart of the bill probably should get at limitations on the third party. Honestly, that seems like the weakest link to me. If law enforcement has the data, they're collecting the data, they're using it responsibly, our concerns are minimized relative to law enforcement is using a vendor. That vendor charges almost nothing because they are happy to collect all of the data and then package and utilize that. And I think it could be as simple as contract requirements that indicate acceptable uses of that data so that they have authorization to utilize the data for law enforcement purposes, but then basically say, we're not allowing that data to be utilized for any other purpose outside of law enforcement or something along those lines. That seems like a reasonable approach. But again, we'll have to work on that and think it through. That's just kind of what was coming to mind as we were listening to it.
One more thing.
Go ahead.
Thank you, Mr. Chairman. And one more idea that was brought to my attention that I've been seeing from constituents that are talking about this very issue is what are we going to do in a situation where there is someone who is a law enforcement officer, but they misuse the tool that's been provided, and someone could be using the license plate to be able to track somebody like an ex-girlfriend, and there are cases like that happening across the country. And so what do we do in that situation? Do we come up with a state statute? But that is kind of different
That's
from
different, yeah,
what
but-
we're doing here.
No, that's something maybe to think about. We already are going to have some statute in play for abuse of power or something along those lines, but I don't know exactly what's relevant, and maybe we can hear from Wascop and get a little feedback later. It doesn't have to be today. Certainly, in fact, we're running low on time, but go ahead, Senator.
Thank you, Mr. Chairman. So just something we might want to think about is asking our staff to look into, the third party issue, right? So third party they rent property from someone who has property next to the interstate.
Yep.
They set up a camera. That's perfectly legal. I can sit out there and video all day long, as the law is currently written right now. And I'm not sure what the bounds are for us to limit that. And so I don't know if that would warrant a little bit of research. I'm sure other states have looked into that. And I'm sure there's some case law out there. I think it might behoove us to delve into that a little bit, maybe get a short memo on whether we can even do that. And if so, what that looks like, or if not, what that looks
Sure.
like.
Good question. Let's focus on that. Talise, go ahead.
Yep, Mr. Chairman, can you just clarify a little bit more on what you're looking for?
Senator.
Thank you, Mr. Chairman. So, Talise, I guess what I'm looking for is some information on whether we can actually limit third parties. If we can constitutionally limit third parties from collecting data, for example, along the interstate or at an busy intersection in downtown Casper, can we do that? Can we limit third parties? Now, we could limit the government from contracting with those third parties, but the question is, can we constitutionally limit the third party from recording the data, keeping the data? And if so, what's that look like? And I'm sure there's case law on that. I would assume there is. And other states, I'm sure, have looked at this as they have passed these LPR prohibition statutes.
Well, ironically, the data ownership and privacy approach actually finds a constitutional legal approach, but it's a rather significant change in approach. It creates a property right to data effectively, and then a use case. We'll talk more about that after this little break we're about to take for the data. So there is an angle hook, but it takes a couple of interesting steps.
Mr. Chairman, I guess hopefully what I'm asking makes sense, and
Yeah.
at least have a little bit of research behind where we think we might end up going with this issue.
That sounds good. All right, we're a little behind schedule because we had robust testimony on that. Let's take our break now, which was the 3:30 break, and then we'll come back and we're going to very briefly talk about the last two little provisions of our personal data privacy and ownership when we come back, and then we'll get into cryptocurrency mining and energy infrastructure update. So let's try and make this a short break and start back up at 4:05. Thanks, everyone. All right, let's get back started again. We've got just a couple more topics within our data privacy and ownership discussion. And then we'll move on. Mr. Co-Chairman, State Location Privacy Act, we're going to have a little bit of discussion about that. The idea of protecting location data, there's a component of that in the geolocation of the previous bill. So we had some discussion on that. And I think we'll just move past that and get to a little bit on data ownership and privacy. Mr. Co-Chairman, I wanted to introduce, we've got a beta draft, we'll call it, a pre-draft piece of legislation that is on the website and that we have copies of that I spent some time working on. The history here is that we've been talking about putting together a strong Personal Data Privacy and Protection Act for as long as we've been having this task force and select committee for many years now. Other states have had privacy acts of various types, starting with the California Consumer Protection Act or Consumer Privacy Act. Moving across the country, Washington has one, Colorado has the Colorado Privacy Act. And over the years, we've drafted a few bills of our own modeled after that, which are tending towards consumer protection as the emphasis. And they all have giant loopholes. They're all based on the premise of everything's okay, but we'll try and limit what large companies do with your data. And none of them have ever looked very satisfying. What we've tended to talk about is the idea of approaching it from a different perspective, which is that your data is your data. It's actually a property right, not a ethereal piece of consumer product, but actually property. And if you treat it as property, then property statute starts to take care of a lot of the privacy rights that you might have and a lot of the appropriate use cases. But we never got to the point where we had a bill draft that really accomplished that. And so I spent some time putting together a bill draft to accomplish that. And so this is the pre-draft that we will look at, Mr. Co-Chairman, more in earnest at the next meeting. But this is an attempt at finally trying to get to that point where data becomes imbued with property rights, and the state of Wyoming has significant authority over property rights, much better than any other really area of statute. So it tries to take advantage of that. So the concept of this bill is that personal data becomes legal property of a Wyoming resident. It's not any new privacy notice scheme or anything along those lines. It's an extension of property law. The concept here is to use property law concepts to drive how your data is managed. So rather than establishing new laws and rights, it effectively treats this as an intangible personal property and then subjects it to property concepts that the court already knows how to deal with, like concepts of bailment, easement, trespass, conversion, and all of that is well established and rooted in existing property law, Uniform Commercial Code, and robust case law. So there's a lot there to hang the property or the privacy on, and a lot of protections there that can be respected and are required to be respected by courts in other states. So property ownership under this proposed act would basically imply a title, and that the title says stays with the resident no matter how many times that data changes hands. So this is property that can't be sold, which is kind of a key concept, right? You can't sell the data, but you can enter into bailment relationships or other relationships for that property. And if the government is utilizing your data for something that they're using it, it's more of a public use of private property, which is well established and fairly common. Some type of easement is understood. And if somebody that you don't want to be utilizing your data is using it in an unwanted way, that's going to be trespass or conversion. And then when you look at federal law, which is obviously going to preempt a lot, and there's a lot of intrusion upon data, it's handled through effectively equivalent of a limited easement that is effectively granted. And that's the concept. It puts out 4 tiers, different tiers of that data in how it's managed and what rights are assignable to that. The tier 1 rights are very sensitive, like genetic data, neural data, personal data of a minor under 13. And those are absolutely inalienable. There's no commercial licensing for that, but there are permitted uses where you can have lawful uses where the owner grants authorization for use, but not licensing, and basically always has the opportunity to revoke that. Tier 2 is opt-in required and relatively short use, highly restricted, but you can always opt in, but without an express written authorization. There wouldn't be the opportunity for a third party to use that and easily revoked. Those are things such as biometric identifiers like we discussed, precise geolocation, and risk-based categories like data revealing status, beliefs, association, lawful activities, et cetera. So other privacy rights. Tier 3 is opt-in with a little more oversight. That's like personal health data. HIPAA is already covering a lot of that, religious beliefs, et cetera. And then tier 4 is everything else, so residual category, but still your personal data about you, and a license term of up to 24 months where you're going to have a little more flexibility on how that license would be provided to third parties. So this is a substantial change in concept. I don't think we'll walk through the bill at this point in time, but I did want to share the bill draft so that the language can be looked at and any interested stakeholders can take a look at how this is structured. For next meeting, Talise will put it into a real bill draft form and work through it and do a better job of appropriate statutory construct. So we'll have an opportunity at our next meeting to work through it in a better form. But it's a fundamental change in the philosophy of data. I mean, entirely fundamental. This is a very big deal and a heavy lift, Mr. Co-Chairman. If we implemented it, candidly, it would make a lot of companies mad because our data is a commodity, right? The data about us, the data we generate. We had conversations just about license plate data being packaged and sold. All of the data about us is packaged and sold because it's not ours. It's whoever is holding it at the time, and they can do whatever they want with it, and there's no limitations on it. And there's no reason under statute, getting to Senator Crago's discussion a little while ago, how can we hook into this? There's no reason under statute why we would be able to hook into it unless it was something like property. By saying it's our property, all of a sudden we have the strongest rights to it under statute. One thing I want to point out is this legislation is very careful not to infringe on our more fundamental rights like privacy and other things. It doesn't diminish any of that. And one of the concerns with this type of construct when we first started talking about it is the idea that you could actually assign away your data rights, assign away important information like your genetic data. And this draft carefully precludes that. So a lot of work went into this, but it's certainly a long ways from being a finished product. I'm looking now for feedback. It's gone through about 28, I think, revisions to try and get it to where it's at right now. And a lot of scenario testings using AI where AI considered the bill draft in a lot of contexts, 30 different scenarios, and whether it handles it appropriately. And appropriately doesn't necessarily mean it makes people happy. It just means that the law managed to provide clarity on a specific scenario where somebody's probably mad about that clarity, but it was clear. And Mr. Chairman, one of the last things I'll say, and then I know we've got a little bit of public comment on this, is that this is a heavy lift and a fundamental change that I don't think industry is going to like. I think, honestly, it works reasonably well from a government and governance standpoint, getting back to the things we were discussing a few minutes ago. You've got affirmative rights to access data within the state of Wyoming, so that corresponds to the equivalent of an easement or a public use. And those things are going to continue to stand. But it really gets into the point where if you start commercializing and monetizing data and you don't have permission for that data, then you're in a world of trouble. If you're using it short of that, like it's going to generally fall into fair use. If you're using it for journalism, or if I took a picture of this room right now, I would have data about all of you, but I would not be monetizing it. It wouldn't be commercialized. And so while that is a use of personal data, it's a fair use of personal data that's going to be allowable. If I then start selling that because it happens to contain a picture of one famous person, well, then that starts getting into a commercialization or basically a trespass, so to speak, of that data right, or a conversion, I believe at that point is a conversion of the data right, and would be monetized. So that's a high level view, Mr. Co-Chairman, of what this bill does. I'd pause to see if there's any questions at this time from the committee, and then we'll go to a little bit of public comment. And we'll try and expedite that public comment because I don't want to fall too far behind. We have our next topic ahead of us and need to get to that. But any questions on the concept of this bill draft from the committee?
Mr. Chairman?
Go ahead, Mr. Co-Chairman.
Yeah, Mr. Chairman, I'm a big believer in go big or go home. So I appreciate the work that you're doing. And I don't think that we should let fear break our stride. So.
Thank you, Mr. Co-Chairman. Yeah, this is a big deal. And this would, first of its kind in the world, certainly it falls in line with a lot of what this committee has done. There's nothing even close to it. It would be far and away the strongest privacy right on the planet. And I would love to be the state that does that if we can get there. And I don't know if we can, but always fun to aspire to big things. Any further discussion before we go to public comment? All right, then with that, do we have any public comment in the room at this time? And for this public comment, since we're going to be looking at it in more detail at the next meeting, I'd ask for about 2-minute speeches if there's any public comment on this topic. Anyone in the room? Go ahead. 2 quick minutes, please.
Hi, my name is Dave Rowland. Mr. Chairman, I agree with you. One of the things that I mentioned yesterday, that looking at your law proposed and looking at what self-sovereign ID, they are compatible.
Mm-hmm.
So it's really a case of where it's stored is where the self-sovereign ID part comes in, protecting it in any kind of situations. That's where yours, so it really, they're hand in hand great. So thank you.
Thank you, Mr. Rowland. And it's not an accident. I included self-sovereign digital identity principles into it, as you can imagine, so that it would be compatible, recognizing that eventually we would do that. Yeah.
Good job.
Thank you. Any further comment within the room? All right, seeing none, let's go online. And I see Ms. Kaiser has her hand up, and Ms. Kaiser has been working with the Select Committee for many years, and in fact is a longtime advocate for the concepts of owning your data and has an organization associated with that. Ms. Kaiser, welcome. The floor is yours.
Thank you so much, Senator Rothfuss and members of the committee. My name's Brittany Kaiser. I'm the president of the Own Your Data Foundation, a Wyoming-based 501c3, and CEO of Alpha Compute, NASDAQ ALP, where we specialize in confidential computing and fully encrypted AI workloads so that you can own your data while processing AI. I think I'm very excited today because this has been the culmination of work over the past 8 years, and really based off of the 2018 law that we introduced through this committee and ended up passing, where your digital assets are your intangible personal property. It also follows on from case law that I helped to establish at the Supreme Court of Minnesota in 2019 in McCarthy v. Equifax, where I helped win the first case against Equifax for property damage for the data breach. And that turned into the federal and national decision, which led to case law that you own your data as your property because the property damage was what everyone was compensated for in that data breach. Over the past many years, there's been an increasing international interest in data ownership and being able to value data as a balance sheet asset. China being the first country to actually do that, and companies in China are starting to add the value of data as a balance sheet asset and defining it as property on their balance sheet. This has now been introduced to the Isle of Man, to Brazil as a federal law. There's now a federal data ownership law in Brazil where you not just have property rights to your data, but the rights to its monetization and at least 50% of that value. Now, I think a lot of people here, and generally what people think is that this is very controversial for companies because we're trying to take a percentage of their bottom line, which is really the opposite. If companies are able to incentivize individuals that their data can be safely and consensually licensed from them, where they have rights to its monetization and can actually earn money by creating data, in fact, people are going to be spending more time on platforms and creating more data, which in the age of AI is great to feed AI models, and it's a win-win. Companies will make more money and individuals will make money for the time that they're spent on platforms instead of just being taken advantage of. It's also a great use of smart contracts where you can license data out to platforms all over the world consensually in a way that I think it's easiest to compare to Airbnb, that if you own your data as your property, just like you own your house, you don't give up your property because you license it. If someone wants to use it, they tell you who they are, how long they want to use it for, what they're going to use it for, and you agree on a price before you hand away the keys. And if someone damages it, you get legal recourse and compensation, and of course you get the keys back. So to be able to incentivize people to produce more data because they are paid and to have these consensual and permission-based terms really means that I think the only thing missing in the bill draft that I had to look at was rights to monetization to ensure that you can get paid through the licensing of your data and not just fees for legal recourse if something goes wrong. So I do believe that this is good for the age of AI. I believe it's good for a transparent and more consensual relationship between individuals and big tech. And I do believe that Wyoming has an opportunity to lead. I helped co-author the New York Privacy Act, which included data ownership rights. That did not go through in 2019, 2020. And then last year, I also authored a data ownership bill for the state of Virginia, which has not yet been introduced. So while CPRA does have the rights for you to demand knowledge of whether companies are monetizing your data and for how much, it doesn't give you any rights to actually demand some of that revenue for yourself. So I think adding that into the bill is probably the final thing that you need in order for this to be very strong and for Wyoming to lead the way, not just in the US, but in the entire world on something that is already becoming incredibly popular. So thank you for your time.
Thank you so much, Ms. Kaiser. Any questions for Ms. Kaiser? Any questions at this time? All right, thank you so much, and I appreciate it. And we'll continue to reach out and talk through this draft as we start putting it into a form for the next meeting. So thanks for sticking with us all these years and continuing to work on privacy with Wyoming.
Absolutely. Thank you for having me.
Thanks. All right, I see Ms. Aronow as well. Welcome, Ms. Aronow. Please introduce yourself, and the floor is yours.
Thank you so much, Mr. Chairman, members of the committee. Erin Aronow, representing Rocky Mountain Farmers Union, and thank you for allowing me to testify remotely today. Just a little bit about who we are, because we're not normally in front of you all. RMFU was founded to ensure that individuals in rural communities can compete effectively and fairly in the marketplace. It's a grassroots organization across 3 states, and our policy positions are adopted by our members. We really applaud this work on personal data privacy and stand strongly in support of it. We like the concept of treating personal data as a private property and the broad rights to control that data that would come along with it. Additionally, the concept or the phrasing that the previous speaker just mentioned, the idea of transparent and more consensual relationships is core to or is key to that. I want to remind you that just like personal data, the data generated from farm or ranch operations has value, and we think that the producer should have meaningful control over how that data is used. Today's farms rely on precision agriculture, digital farm management tools to remain competitive, and these technologies generate that valuable operational data from crop yields to livestock health and beyond. And while these tools provide tremendous benefits, there's information that can be commercially exploited, just like the data this bill is meant to address. And so we'd ask that as you continue to work on this bill, please make note of how concepts in this bill could be used to protect agricultural data in the future. We enthusiastically support a bill that would protect personal data ownership and continue to consider those agricultural rights as you move forward in the future. And we're happy to work with you on that. Thank you. I stand for questions.
Thank you, Ms. Arano. Any questions, committee? Thank you, Ms. Arano. And I will note that this is drafted obviously as natural person, personal data property ownership. The long-term vision would be to have if this passes, a next generation companion bill, which gets to the organizational, which would include corporations, farms, and that type, and have a similar analog bill. It would be a different set of rights, certainly, but that is the long-term puzzle piece vision. So it's consistent with that interest that you raised.
Wonderful. Look forward to working with you on that.
Thank you so much, Ms. Arano.
Thank you.
All right. Anyone else online at this time? Okay, seeing none. One more public testimony in the room. Please join us. Once again, we know you, but introduce yourself and welcome.
Thank you, Chairman. My name is Scott Moeller. I'm one of the founders of the American Crypto Fed. And the reason I wanted to come up and speak on this is 6 years ago, in June 11th, 2020, the Merchant Advisory Group leads talked about how powerful it would be to have how important it is to have privacy, identity, and the need to have a universal identity, some solution, but not have that be controlled by the government. So if I can share with you a little bit of what they talked about years ago, and I know they absolutely would want to get engaged with you now. So, and to remind, the Merchant Advisory Group is a consortium of the top 200 merchants in the United States. Annual sales for these merchants exceed $5 trillion per year, and more than 60% of the credit card spend in the United States goes through these merchants. And I'll give a very, very short quote. And this is from John Dreschny, CEO of MAG, and Kathy Hanna, who at the time was chair of the MAG board and head of payments at Grover. Our society in general, and the payments industry in particular, needs a free, universal, secure, and open solution that establishes a universal digital identity solution. And that tool is still missing. So identity is the sort of problem that benefits from one universally recognized solution. It should be a public benefit infrastructure, but not controlled by the government. MAG merchants would like to work with your committee to create a legal framework for a universal digital identity solution. For MAG merchants to adopt such a solution across the United States, the solution must fit in the existing federal, state laws and regulations, which MAG merchants currently have to comply in the normal business course. And I don't need to go into all the details, but one of their key points was privacy and the ability for an individual to own their own data and establish sub-avatars for sharing that data for certain context. Okay, so this could be incredibly powerful for Wyoming to lead this. So you will have buy-in from the merchant community on this. So it would quickly go from a state solution to a national solution, and I believe international pretty quickly. And yeah, it'd be very fun to work on this. So you're going to get many merchants, and Brittany's awesome too. I know her for years. Okay, thanks.
Thank you.
Open for questions if you want.
Yep.
but-
Any questions, Mr. Muller?
Okay.
No. Thank
Thank
you,
you.
Scott. Appreciate it. And we'll probably need that support because I think we'll have some other folks that don't like it as much. So getting some industry that does like it isn't going to
Understood.
hurt.
Yeah, yeah. Well, they need a solution that works. No one likes to have, 50 passwords, 100 passwords, sign up for something again and again and again. So they need something that works.
Absolutely. Thank you. Appreciate the testimony. Any further public testimony?
Mr. Chairman?
Yep.
Mr. Maher just raised his hand.
All right, great. Let's bring in Brendan. Maybe. There we go.
sorry
Brendan,
for the technical.
we can see you, we can hear you. Give us 2 minutes of your thoughts on this bill.
Okay. Brendan Marr, computer scientist, involved in many of the working groups. I want to say first off, this bill is just tremendous. It is groundbreaking. And I want to touch a number of things real quick. First, some things that are good, some things to think about, some minor definitional, a small definitional concern. I want to say this, that the whole idea of having a root basically in bailment is extremely important. And that what I really want to get to say is a little bit more on how this relates to the Personal Enclave Act, because I think that to make this operational, you really need a Personal Enclave Act, which gets to what Ms. Kaiser was talking about. And incidentally, she left out that she was on the working group for the Wyoming's very own Digital Identity Act. So she goes back a long way here. But to make things operational, you really need the complementary organization to put it in practice in order to have rights and monetization. What is different about where we are right now with AI is of note. And it is that traditionally what we have is systems where you throw your stuff out into these big tech companies and there's no really connection between the data that you put up there and how they're using it and all this kind of stuff. But this fundamentally is changed going forward because of the way we connect to big tech companies and AI agents. Because whether you're using a chatbot or you're connecting to a company through an API or an MPC server or whatever, basically you have a direct connection pipe. And what this means is that you can do something around privacy. You can do things around privacy that you could never do before. And that would be things such as this, where you could, in your chat, you could say, listen, don't save this. I want you to make sure this gets deleted from your buffer, these kinds of things. Now, it's not so simple, and it has to be worded very well. But to draw some examples of some of the aspects of the bill that need some consideration. And I want you to understand too, what I'm about to suggest and read, I don't believe actually goes into this bill per se. I think it has to go into the Personal Enclave Act or something of that nature, because it's a lot to put in this bill. It's not necessarily appropriate, but these are the short comings of the bill, and in terms of things to think about. And it would be around things such as this. If you have the Personal Data Ownership Act, it would need to consider questions such as, can an AI agent consent to a data license on behalf of a person? Can it revoke consent? Can it exercise or deletion rights? Who's liable when the agent exceeds instructions? There are other things such as around principal and identification. If the AI agent is embedded in a consumer app or a custodial platform or a wallet or an enterprise workflow, can the act say whether the regulated model provider or deployer or orchestrator or credential issuer is the user's principal or all of them jointly? There's issues related to distributed ledgers, because all of these things will have bindings with keys for distributed ledgers. And when it comes to deletion of property, it's not so easy to delete those distributed ledger keys, which may be associated with this personal property. So there's lots of things to consider here. I think I'll leave it at that. But the most important thing here is that we have a really great bill that gives us a platform to really think about digital identity differently, because the infrastructure is different. I'll take questions.
Great, thank you. Thank you, Mr. Marr. Any questions for Brendan? All right. Seeing none, thanks, Brendan, and we'll certainly continue to get the drafts to you as well to review as this moves forward. So thank you once
Great.
again
Yeah,
for
thank you.
your participation. All right, any further public comments in the room, online? Seeing none, public comments closed. All right, and Mr. Chairman, I don't know if we have any committee directives to speak of. I think we're continuing work. We have our directives on protected expression, limits on foreign judgment. We already talked through what we're going to do with the license plate readers, refine that draft, narrow it down, and then this is going to be drafted into something for us to consider next time. So I think we're generally in good shape. Committee, anyone have anything to add? All right, seeing none, let's move on to, it's now 3:45. Sorry to the good folks that were here on time and have had to wait through a little bit of unintended data privacy conversation. With that, we've got our 3:45 topic, cryptocurrency mining and energy infrastructure. This is something that's been on our agenda for a number of years, just looking at the state of cryptocurrency mining in Wyoming. And we've had an ongoing conversation about power generation arrangements and potential concerns for large power loads. So we'll have a little discussion about that. Let's start off with cryptocurrency mining updates. And let's see, who do we have? Do we have anyone in the room today? I don't think we do in the room today. So all online for this?
Yes, Mr. Chairman, we have Joe Terranova online as well as Representative Filer.
Excellent. All right. Well, let's start with Joe Terranova and welcome Joe. All right, Joe, good to see you again. Please introduce yourself and let us know how things are going.
Yes, thank you very much. First of all, can you hear me okay?
We can.
Okay, great. Good afternoon, everybody. Chairman Rothfuss, Co-Chair Singh, members of the Senate Select Blockchain Committee. It's very nice to be here speaking with you, and thank you for the opportunity. My name is Joe Terranova. I'm the Chief Operating Officer of 44 West Mining, which is a Bitcoin mining operation with base operations in Gillette, Campbell County, Wyoming. Since I spoke in front of this committee in May of last year, Bitcoin mining has become more challenging globally. Increased adoption of Bitcoin and notably other high-performance computing applications has significantly increased demand for suitable data processing sites and equipment, which has in turn reduced availability and increased cost for those resources. At the same time, energy prices continue to rise, which utility companies in Wyoming are certainly not immune to. For 44 West Mining and our peers throughout the Powder River Basin, this trend had previously necessitated a shift in operations, specifically resulting in significantly reduced uptime in an effort to avoid peak usage periods. And as a byproduct of those reduced uptimes, stagnated business development, reduced participation as workforce catalysts, and significantly lower tax revenues flowing through to state and local municipalities followed. It's important to note that Bitcoin mining economics have strained companies of all sizes, with many of the smaller operators, nationally and globally, reporting recent operating losses, repurposing their facilities, or shutting down entirely. However, industry-specific challenges are only one piece of the puzzle, and they alone do not preclude the ability of companies such as mine to stay viable. So if we zoom out a bit, Wyoming continues to cede ground in emerging technological industries to other states such as Texas, and other states with deregulated energy markets and or tariff structures tailored specifically to high performance and high density computing applications. 44 West has long advocated for a new tariff featuring a true interruptible rate that would enable us to maximize uptimes while responsibly conserving energy when demand peaks elsewhere in the system. And underscoring that point, Bitcoin miners are uniquely positioned to positively contribute to planning for distribution co-ops and grid balancing best practices, given their ability to self-regulate their deployed load with only a few minutes notice. Excuse me. Such flexibility is an asset to the utility and to the larger grid. Before commenting further on that specific item, I did want to take just a moment to express my appreciation for two groups that have supported our efforts in this area. First of all, I'm thankful on behalf of my company, thankful to the committee for continuing to invite 44 West to participate in legislative sessions, and more notably in directly engaging with the utilities and co-ops servicing the state of Wyoming in an effort to help ensure greater transparency and accountability from upstream operators. Secondly, I want to recognize the efforts of the entire team at Powder River Energy Corp., who more than anyone else has worked to align with 44 West in all of our operational and business development efforts. Unfortunately, in spite of this support and the considerable time, energy, and financial resources committed by 44 West towards advancing our development goals, our efforts continue to be stymied by a nearly insurmountable roadblock originating from entities whose commercial interests often stand in direct opposition to those of their customers. To wit, 44 Mining currently operates as a pilot participant in the Coincident Peak Management Program, carved out from the power distributed to us from Precorp under Basin Electric's large power time of use tariff. As a note, this pilot program was rolled out partially in response to last September's meeting of this same committee, following reasonable questions from committee members as to whether or not certain G&T co-ops were fully meeting their mandated obligation to serve. The prior segment of, well, some of the prior segments of this meeting notwithstanding, I contend that this pilot program satisfies a narrow interpretation of the offering of an interruptible rate structure, while falling well short in practice of providing a sufficient solution for operators like us and the distribution co-ops that service them. And perhaps the most troubling aspect of this situation is that it seems to be at least partially reconcilable with little more than additional data sharing. However, every such request that we've made for greater collaboration and transparency has been cut off at the pass, generally without any reasonable explanation. So at the end of the day, we chose to set up our business in Campbell County for a number of personal and commercial reasons. We're now in year 5, but our vision remains the same as it was at inception, which is to develop a long-term, sustainable business using local labor and vendors, serving as a net contributor to commercial development across the county and the state. And in the course of doing so, we've aspired to serve as a model for like-minded companies by conducting ourselves in a manner that serves the best interests of a broad array of stakeholders without unduly burdening the natural and personnel resources in the area. So with those goals in mind, the bigger picture should remain clearly in focus. Investment into crypto mining and related industries in Wyoming has been limited by the lack of a suitable rate structure, in part by the lack of a suitable rate structure among Wyoming's co-ops. With a digital revolution upon us, investments are being made in other states and countries to secure the aforementioned data processing sites and associated equipment. And with Wyoming's abundant energy production and progressive attitude towards blockchain-related applications, the time really is now to figure out how to bring those investment dollars here. And the potential for job creation, increased state and local revenues, and economic development cannot be overstated. For myself and all of us at 44 West Mining, we aim to grow along with the Bitcoin mining industry statewide, and we'll continue to advocate for actions that directly advance that goal. With that, thank you, Chairman. Thank you, Co-Chair. Thanks to the Select Blockchain Committee for allowing me to speak, and I welcome any questions that you might have.
Thank you, Mr. Chair Nova. I appreciate you. Once again, appreciate you taking the time to attend and provide us with that update. Select Committee, any questions for Mr. Chair Nova at this time? Joe, I do have one question. I just wanted to follow up. Obviously, we did prioritize this last year, and we're under the impression that with the new approach that was being offered, you would have more access to an interruptible tariff approach. It sounds like from your testimony that was implemented, but still is unsatisfactory in really providing you with the opportunity to understand the rate, what the rate is going to be in advance, and you still have the prediction problem or the hindsight problem. Is that accurate? Can you walk us through a little bit more exactly what you're experiencing with that and how it's operating now?
Sure. Thank you, Chairman Rothfuss, for the question. I'll try to not meander too far into the weeds. I have a tendency to do that when talking about this stuff because I'm a nerd and it's very important to me. So in short, what was introduced, and again, I'm recognizing that it was partially due to some of the limitations of all of the different stakeholders that need to interact to modify a tariff or roll out a new tariff. But what was introduced effectively is effectively a synthetic interruptible rate in that it's a year ahead forecasted rate structure that allows our ultimate G&T co-op to manage 12 months worth of energy distribution in a way that they can reasonably predict won't unduly burden their operations, but will also doesn't really give us the opportunity to participate when at all times that conditions would normally call for it. So what happens to us in practice is that we have our rate structure, we have our permitted uptimes for specific months of the year. 7 of those months out of the year, uptime is effectively close to 50%, give or take a few percentage points, whereas the other 5 months, it's 100%. So people will have different ways of looking at this, and they may differ from mine, but the way that I look at it is that if you're mining cryptocurrency that can be monetized in the open market, just like anything else, if you're making widgets, downtime is a loss of opportunity. And if you have a power rate that's, let's just say 4 cents per kilowatt hour, but you're only running 50% of the time, then your effective power rate, net of what you can sell of the widgets that you make, is basically 8 cents an hour, 8 cents a kilowatt hour. And again, that's my interpretation of it from where I sit, and there are people that feel otherwise. And the secondary part of it is that when you're mandated to be off by risk of usurious penalty for such a high percentage of the time of the year, you are much more susceptible to downturns in economics of the business. A company that's on 95% of the time can very easily weather a 10% downturn in economics because they have more opportunity to produce when they're on. We're just not able to do that. And, our uptime coming in somewhere around 70% for the year under this tariff rate is certainly more beneficial than being at 55% the way that we were before, but it doesn't raise the bar enough to get operators such as us over the threshold where we can reliably plan our business. And secondary to that, it also really where it really shows is it really hinders our ability to engage in commercial expansion. And that's something that we've been behind the 8 ball on this whole time. So in short, it's not a true interruptible rate in the sense of the word. We're working with Precorp to try to make it look closer to that. But again, without ample access to data that theoretically should be available to Precorp anyway, as a member of co-op, it's almost impossible to implement those predictions. It really is. And that's the challenge that we find ourselves facing right now.
Thank you, Mr. Terranova. And where is the data being withheld? And I understand what you're saying about how you're not really an interruptible. It makes sense. It's sort of a probabilistic model instead of an interruptible actual model. I see what is going on, and you want to be in a situation where it's a responsive interruptible so that if you need to shut down, you shut down, but it's for a minimum amount of time. That makes good sense. Where is the data stopping? Is Precorp not getting it, or where in the chain of
it's a little, thank you, Chair Rothfuss. It's a little bit of a black box for us, to be honest with you. I have, I kind of have my not opinions, but by piecing together the different discussions that we've had with Precorp, even one discussion a couple of years back with Basin directly, and then the final piece would have been at September's meeting of this committee. Our understanding is that Basin Electric operating as a multi-state investor-held entity, they have different interests, different business interests than their member co-ops, and then by extension, the customers of those member co-ops. And from what I heard at that September meeting, the message was from Basin, we entrust our member co-ops to conduct their business as they see fit. So what does that mean? It means that we get forecasted data, and Precorp does, and they've shared it with us before, and we have used it prior to signing on to this rate. You get forecasted data that has almost no relationship to what actually happens in practice and what the actual numbers look like. And so where that data gets not corrupted, but where that data goes askew of actual daily operations, I don't personally know. But I would presume that a large entity such as Basin Electric knows they do know what they're doing. They know how to run their business, and their decisions are informed by the data that they receive and interpret for their benefit, for the benefit of their stakeholders. If there were a sharing and there was transparency in terms of what their market rates look like for power, or when power prices spike, just like how they do in Texas, I think that would be very meaningful to Precorp, to us, to all the businesses that are like us, even to the plants that are in the county. But we just don't see it. And we have offered to, at our own expense, crunch those numbers at our own personnel power, crunch those numbers, and come up with a plan that doesn't hold anybody to anything. And we just haven't received that. And I think that, by extension, in my conversation with Precorp, they're fairly limited in what they receive as well. But again, I don't know the definite answer to that question.
Okay. Thank you. That's helpful. I appreciate it.
Sure.
Any further questions for Mr. Chernova? All right. Thank you, Mr. Chernova. We'll be in touch, and obviously we'll keep you in fact, in the September meeting, if you'll join us in Laramie, we'll continue the visit.
Great. Thank you so much for having me here. I appreciate it.
Absolutely. Appreciate it. All right. Clarissa, do we have Representative Filer available? Okay. Let's bring on Representative Filer.
Mr. Chairman?
We can hear you. How you doing?
Oh, good. I would turn on my camera, but I am stuck in an airport in Cincinnati, Ohio, and I don't think you need to see everybody around here. But anyway, Mr. Chairman, Lee Filer, I'm taking off my representative hat, and I'm here to speak on behalf of Kryptonite Hosting, or Kryptonite LLC in Laramie County. Just to give you a little bit more of a high level, our numbers are a little bit larger than they were in the previous year on our tax revenues that we have paid in. Our expansion plans are coming through, working through some final details on that, where we will be up to about 76 megawatts of power running in Laramie County here once all the permitting and everything like that is complete. Our employment numbers have stayed the same as last year. We're averaging anywhere between 18 and 22 full-time employees. What else can I give you? I'm sorry, Joey's been busy with our customer today, and we had a curtailment also. But he can give me a little bit more numbers and how things are working with our utility companies. I do want to thank both our utility providers that we are working with. That would be Black Hills Energy, top-notch group right there, easy to work with, very easy to get data from them, what to expect, how much things are going to cost, timelines. They're very prompt on those types of issues. Our other provider, High West Energy, Jared and his team over there are very easily to work with. But sometimes we fall into those same hiccups that we just heard from 44 West, which is, if we come up with an idea, maybe we can go this route or another route. It's usually up to the generation company, not actually the co-op. So it falls on deaf ears, it feels like sometimes. There is times lately that we have been getting some headway where we're getting a little more information from the generation side, which is good because we are looking to hopefully expand our operations on that side of town also. But anyways, from there, Mr. Chairman, I think if we don't look at, we got to keep looking at too. We got a happening coming up. Infrastructure wise, equipment is getting a lot more expensive for more high efficient equipment. As we swap those types of things out, it is a very large CapEx on that. But with the rate structures that we have now, especially after the happening, is going to be pretty rough. And I'll stand for any questions.
Thank you, Representative Filer. Any questions for Representative Filer at this time? All right, thanks. And you're going to stay on, so we'll have you available when we start to get into discussion. I appreciate the update.
Yes, sir.
And Clarissa, anybody else this time? I don't think we do. Okay, thank you. All right, so committee, we have on the agenda a few topics to look at that we had under consideration last year and we talked through, and we've got once again, those include, let's see, discussion of third-party power generation arrangements, large power load regulatory considerations, and then public comment ahead. On the third-party power generation arrangements, little update, the Minerals Committee and the Corporations Committee have both had some conversation around this. I'm going to have Representative Yin talk a little bit about what the Corporations Committee is up to in a few moments as he puts those thoughts together unprepared. And I'll talk a little bit about where Minerals is at. We have had some discussion in the Minerals Committee related to third-party power generation. A couple of bill drafts are bouncing around, and we'll see what those end up looking like when we get to the next committee meeting that provides authorization. But I think the primary concept is that our Public Service Commission has been preparing a third-party power generation rule. And that rule is effectively under review at this point in time. The Minerals Committee adopted a motion to prepare that rule as a bill draft. And that is something that will be under consideration at the next meeting. That provides some options and some opportunity. It doesn't necessarily go as far as we've discussed at some points in the past of just opening things up, but we have that as a potential option. And we'll keep watching for that. My inclination there is probably to see what direction the Minerals Committee goes before we start tackling third-party power generation on this committee. If it looks like they're going to be able to move forward through the Minerals Committee, or I'm on that committee, then that would probably be an appropriate approach. But we'll see what direction that goes. Representative Yin, I gave you about 2 minutes to think through what your last meeting was like, and here's your opportunity to share with us.
You know, I mean, I think part of the issue is that a couple of people here were at, I mean, I'm sure they were at both Minerals and Corporations. So
they were.
They can correct me if I say anything wrong. I think generally what we did in Corporations was get kind of an overview of what the landscape looked at, because Corporations, the committee that we currently have has not focused on electricity a lot. And so I think what we got was basically what the landscape looked like, as well as not just the landscape of what's in place, but what are the issues that we need to work on. And some of it was around third-party generation. I think that discussion was in place there, as well as around transmission infrastructure. But I have to say, you know, given that was 2 months ago, most of that meeting that I remember in a blur was about elections and less so about electricity.
Yeah, what was it, 20 bills about elections, something like that?
It was in the multiple digits, for sure.
That's great. Thanks for doing that hard work for us. Appreciate it. All right, and we're going to have public comment, obviously, in a moment. We'll get to that, and I know that we'll have some feedback on what is already being done and undertaken. And that's basically what I'd like is a little bit of an overview so that this committee can understand what is already underway. And I know our good colleagues from the power companies have been working on this with those two committees and here. We're short on time, obviously, and I'm sorry about that. I don't want to keep everybody too terribly late. So we don't have to go into the same level of detail perhaps that we went into with the Minerals Committee and Corporations Committee, but I would appreciate through public testimony, letting the committee know some of the things that Mike and I have already heard about what the ongoing approach is and some of the proposals that are being produced by our stakeholders. And then large power load regulatory considerations, same thing. We've had similar discussions on how, whether we should separately regulate large power loads, have different tariffs, have different requirements. There are a variety of options that I think are in discussion, and that's consistent with the PSC rule, which we'll be looking at when that's finalized as well. And I think we'll probably end up just going to public testimony in a moment to hear about that. But any further discussion, committee, any questions or anything to lead with before we hear public comment?
Mr. Chairman.
Yeah, go ahead.
I briefly just pulled up the minutes from that last corporations meeting, and the committee directives really was just to request a bill draft to match the federal approach to pipeline civil penalties. So we didn't even do anything on electricity. We didn't have any directives on moving forward with the electricity. So it really was, I think, just an overview.
Excellent, thank you. All right. And with that, let's open to public comment and just kind of invite some updates from our service providers on where things are at, and pick any order you all feel like. I welcome you all, and don't hesitate to all come up at the same time. I don't know who wants to. Dave's going to bat last or something. I think he batted first. No, you were last. That's right. He was. Yeah, you're first and he was last. That's right. Okay. And yeah, fight amongst yourselves and let us know. And again, thank you for showing up in person to provide us with updates on what you've all been working on in this space.
I'll go ahead and start. Sure. Mr. Chairman, members of the committee, my name is Sean Taylor, Executive Director of the Wyoming Rural Electric Association, and I can make this pretty brief. But let me start with one thing, and that's a little co-op 101, because in some earlier testimony, it sounded at least that there was, people were calling the co-ops and then talking about the generation and transmission companies. They're all co-ops, right? Our co-ops, our distribution co-ops are owned by our customers. They all formed the G&Ts to buy their wholesale power from. So they're all co-ops, and they're all governed by the same cooperative principles. So when Mr. Filer is talking about working well with High West, but maybe getting pulled up or held up a little bit with Tri-State, that's still a co-op, and they have to answer to all of their customers, all of their members across, in Tri-State's case, New Mexico, Colorado, Nebraska, and Wyoming. In Basin's case, as Mr. Terranova mentioned, again, clarification, we're not an investor-owned utility. He said something to the effect of an investor, that Basin has to answer to all their investors. Those are the co-ops. So in Basin's case and in Tri-State's case, they're all owned by co-ops. Basin does work across, I believe, 9 states, and they have to answer to all of their co-op members across those states. So it can get a little clunky. But what I've shared with the committee, what we presented to the Corporations Committee and the Minerals Committee is kind of our white paper. This is in your board packets. And it spells out really, in our opinion, it answers the 2 biggest questions that we've been hearing for a long time from you all in the legislature, from the governor, from the Public Service Commission, from other industry partners, is how are you going to serve large loads, whether they be crypto or data or AI, or we've now incorporated large loads to include increase in mining operations and oil and gas, all of which we can serve. I know there was an argument when we first started doing all this that the utilities were saying no to companies. We've never said no. Maybe we didn't give them the right answer that they liked, but I think in our mind, under what's spelled out in this white paper, are our answers to the questions. How are you going to serve large loads, and how are you going to protect your current members. We call our customers member owners. I did not bring the big brains to this meeting to go into great detail. And I think you're all probably happy for that. We did go into quite a bit of detail. I believe it was with corporations, maybe with both committees. I can't remember at this point. But I did take some notes from Mr. Terranova's testimony. I'll follow up with Basin and Precor just to see, like, on the data holdup, why can't they get what they need, or because I'm sure there's a good answer to it, but I don't have it. And so I just would encourage you all to take a look at this white paper. Like I said, it spells out for all of our G&Ts. That's Basin, Tri-State, and Deseret. Can't forget about them over in the southwest corner of the state. Southwest corner of the state. They serve a small co-op over there. But all our G&Ts and how our distribution co-ops operate with our G&Ts to answer those two questions and to meet large loads. So at your next meeting, if you'd like some of our folks to come in and put a little bit more detail on that, like we did with Minerals and Corps, we're happy to do that.
Thank you, Mr. Taylor. I appreciate that. Any questions for Mr. Taylor? One thing to pursue a little bit is the interruptible tariff, and this was what Mr. Terranova was talking about. And at our September meeting of last year, we had a good conversation about it. And we had conversations with Rocky, but we also had conversations with, I think on behalf of Mr. Terranova, with our co-ops, and they did suggest that they had an idea and that they were going to resolve that. And we had that bill that we were working on, and then we ended up deciding, all right, let's not run the bill. Let's sort of see how things are going, because I think everybody sounded like they had an answer, and interruptible tariffs were going to show up. And obviously Black Hills has their interruptible tariff that's been a great success. So we were kind of expecting something similar. And now a year later to hear that, I don't know that anything has really happened with regard to interruptible tariffs, but that's one story, right? And you've got more than one co-op that you represent.
Mm-hmm.
Can you provide us with a little more detail on what progress we've made on interruptible tariffs, in addition to just digging into Mr. Terranova's concerns? Have we moved down that path so that we have better real-time access to a robust interruptible tariff similar to what Black Hills has been running, so that operation time can be more in the 95%, which I think is what Black Hills is typically seeing on their tariff. I think operators, you give a call and you say shut down now, and 5 minutes later they're down, where it sounds like this isn't really an interruptible tariff. It sounds like it's a prediction model of, okay, you can operate between 11:13 and 9:16 PM today, according to a model that we came up with. And so they're seeing 50% uptime. That doesn't quite feel like what we were looking at in September. I'll say that doesn't align with what my expectations were, I think, when we were working on that bill draft and decided to set it aside.
Mr. Chairman, I think there's a question in there.
Yeah.
Where is it? Where are we on interruptible
Yeah, exactly.
tariff?
Yep.
I don't have an answer for you today. I do know in the state of in Tri-State's case, who serves 8 of our co-ops in Wyoming, they have a tariff pending before FERC right now. Fairly optimistic that it'll be approved next month in August, and that includes an interruptible tariff. Basin's large load program, again, we'd have to get down into the weeds to see if it is an interruptible tariff or not, or how they plan to proceed to kind of meet the needs of folks that need an interruptible tariff, or they can handle an interruptible tariff. So I'll just say I can probably get you a little bit more detail on that at the next meeting.
That'd be great.
You bet.
Yep. Thank you. That would be helpful. Excellent. Appreciate it. Further questions for Mr. Taylor? All right. Seeing none. Thank you, Sean. Appreciate it. Yep. Mr. Nicholas, welcome.
Chairman Rothfuss, members of the committee. My name is Nathan Nicholas from the Cook Law Firm on behalf of Rocky Mountain Power. As the members of the Corporations and Minerals Committee are aware, we've spent the last 6 months, more or less, trying to define what the problem is. And because without actually having an accurate definition of what the problem is, we can't really come up with an adequate solution. And it seems to us that the third-party generation is kind of a solution. It's the nuclear solution to try to solve all problems, and it doesn't solve any problems, actually. The existing industrial customers that currently operate on thin margins as it is one problem. The solution for that is different. And the solution for what this committee is looking at in terms of infrastructure for data centers and Bitcoin mining, what we call more along the lines of economic development, is a different problem with a different solution. The cryptocurrency boom followed almost immediately by the AI explosion, and then the hyperscaling data center has created essentially a gold rush for electricity. And that's tightened the market all the way around, including lead times have extended on infrastructure products. The queues for service, it ballooned. And as we all know, most of those projects have either gone away now or have been laid back. Probably, some reports are saying 80 to 90% of those hyperscale projects have been canceled. If the utilities had chased those opportunities and started building out infrastructure, we'd be looking at stranded assets all over the country that existing customers are paying for. The question then is, who should pay for economic development expansion on utilities? Rocky Mountain Power's position is that the existing customers shouldn't pay for that. And that's what the regulatory regime right now allows us to do, is we're only allowed to build infrastructure for existing customers and pass that on at a just and reasonable rate. We're not entitled to build speculative infrastructure and then pass that on to the existing customers. And I don't think anyone wants that to happen anyway. So the question is, who pays for that? Well, the problem is that we're getting these speculators that come in and say, well, if you give us the infrastructure, we'll come. So what they're saying is, we will only come if you'll give us the electricity. And it creates a situation where we're in now, where it's a feedback loop where we're saying, well, we can't give you the electricity until you commit to come. They say, well, we can't commit to come until you give us the electricity. And so then it's saying, well, and then we hear from you all and those responsible for economic development, they're saying, well, the utilities aren't participating, which isn't the truth. We're participating within the regulatory regime that we were provided. In order to answer that, Rocky Mountain Power has put together a fairly large package of legislation, and we've sent that to minerals and corporations committees and members of this committee that aren't part of that, and I'm happy to forward that along. But it addresses several issues. One of them is it addresses how do existing industrial customers that are currently operating on razor thin margins expand their operations in order to capitalize on what might be an opportunity in the market. It also would allow utilities to sort of gold plate existing facilities. So if they go into the Laramie Valley, for example, and say, well, we need to build to accommodate for 5,000 more residential units. Well, maybe while we're there, we could build to accommodate for 7,000 residential units, or, whatever, so that we can, so that Laramie can grow. This feedback loop is the same problem that the Laramie Valley is stuck in right now, is who's going to pay for the expansion to run power into the valley. The other thing it does is creates an alternative service pathway for large data centers or large users. The current bill sets that bar at 200 megawatts. So at 200 megawatts, there's a process that the potential customer and the utilities go through, where the potential customer sends a request in the utility responds, does a study, and then provides them with a contract. And if that contract doesn't fall within certain parameters, then that large hyperscaler type customer can go out and seek alternative third-party generation. And then the other one is it also just modernizes some economic development tools, including bonding, loans, and that type of thing for economic development entities to go out and seek in order to build infrastructure for speculative projects. If they want to create a data center park, sort of, think back 14 years ago when we were looking at the Heartland projects, and how do you build, if you build the infrastructure, will they come? And if you do want to build the infrastructure, how do you finance that, and who's going to finance it, and when and how? This helps provide that as a tool so that counties can go out and say, well, we want to put a data center park in, maybe the old WR Metals property. And that would give you an opportunity then to go to the SLIB and apply for those loans to do that type of infrastructure. So that's really what the proposed legislation is for, is to answer kind of the whole ecosystem of problems that are existing for utilities now. But the one thing it absolutely does is protects existing ratepayers.
Thank you. Any questions for Mr. Nicholas? And one thing to note, which that legislation that you provided the draft of is very similar to what ended up passing in Utah that you worked with the state of Utah on. It seemed like you mentioned, and I haven't compared them, but it seemed like you mentioned there's a few tweaks between Utah and the draft that was provided to the Minerals Committee. Was that draft also provided to corporations?
I believe it was. I know we sent it to the chairman, and I think we sent it to the entire committee.
Okay.
I'd have to go back and look through my email.
Gotcha. And so that's welcome to see that. The one aspect of it briefly that we really haven't talked about is the idea, there's no question nobody wants anything to harm existing ratepayers, and particularly like residential customers. So I think everyone everywhere agrees that insulating them is a important part of any policy forward. But the case, and we talked a lot about this over recent years, the case where the risk profile in the view of the utility or co-op for the region is such that you just don't really want to do it. You don't trust it. You look at it and you think that's risky for our operation. We don't want a part of it. There's no real mechanism, and maybe the alternate mechanism that's in the bill draft ends up addressing this. So that's what I'm hopeful it's sufficient. But it should be okay that you all don't want to participate in a project. That isn't necessarily a bad thing. But the way it is right now, if you don't want to participate in a project, nobody can do the project. You basically, and you can't say no. We know you can't say no, but we also know that the process can go a very long time without saying no, and that's just as good. It should be okay for y'all to say very quickly, we don't want to touch that. That doesn't look like it's consistent with our system. Good luck to y'all. Do you feel like the legislation draft as it's written that you presented to the Minerals Committee, which again, we haven't all seen, but I've, skimmed through it, haven't processed it in detail, kind of takes care of that need for existing utilities to quickly say this isn't a project for us and then still have it be able to proceed?
Mr. Chairman, I believe it does. Certainly, one point is similar to the co-ops. Rocky Mountain Power's never said no
We
to
know.
a potential customer.
You're not allowed to, so I understand.
The limited alternatives pathway, though, does provide guide rails, right? If you're concerned about the process taking too long, it does provide, it's got very hard deadlines that the utility has to comply with. And then if they don't meet those deadlines, then the customer, I have to go back and look at the legislation, but I believe that then the customer has the option to go out and seek third-party generation for that. And that's for the hyperscaler loads specifically.
You've never said no because you're not allowed to say no. And you're not going to say no to me today either. But maybe something to go back and talk about, and this can be before the minerals or before we talk about it again next time, is maybe have a conversation about, would it be okay for us to get to say no? For you all, for certain project types, we could define that. It could be over 25 megawatts. So whatever, right? Under certain circumstances, we don't want this power. Well, no, that's not true. You'll never say we don't want this power. We don't want this project because the risk profile, it's just not something that we feel comfortable with the way this is going to go. We think you're going to go bankrupt. We think this will be a washout, and we don't want to take the risk on behalf of our co-op, right? They don't want to get burned, and shareholders don't want to get burned. Nobody wants to get burned. So you don't, you're definitely not going to be prepared to answer that today, but maybe something to think about in this conversation is, would it be a bad thing if you could say no, but that basically means that somebody else can say yes, right? So you build your own at that point, you take on all responsibility, all risk. You're independent from the grid. And if they do want to hook up, then you'd end up having to have a contractual agreement at a later date once they've built or whatever the case is, right? So not put any restrictions on, you can still engage, but you're hands off. Any thoughts for now, which you don't have to have?
Mr. Chairman, I have some thoughts. I'm not sure that they're entirely accurate though. So I would
Fair,
think
yeah,
I'd
that's
like to
fine.
run that by the company
Yeah.
and my client and get back to you. And I'm certainly I'll come back to you with an answer at the next meeting.
Okay, that sounds great. Thank you. And Sean, I'm going to ask you that same question because I didn't.
Well, I don't have a straight answer for you.
It's fine.
But I mean, we want any load that wants to come into our territory. And when you start saying, and you start saying, it's okay to say no, somebody else will do it. Well, somebody else will do that within our certificated service territory. And I hate to sound like a broken record, but I go back to that all the time, is our certificated service territory is our asset because of our nonprofit nature. When we go out to lending institutions, having the certainty that any load that comes into that territory will be served by the co-op is an asset for us. And so if we start to degrade that by saying, we don't want it, but you can do it in our territory, that's going to cause some problems. What we think our white paper and our large load programs get to is if there is a third party that can do this quicker and cheaper, which is one thing we keep hearing, than the incumbent utility, I think we have the basics laid out to where that could happen. We still protect our territory, but we work with that third party and the customers that they may be serving within our territory to work out an agreement to where maybe eventually we get to a point where we can serve it. But for the time being, we give that up until, and we're not there yet. We just started talking about this type of thing. But I think what we have laid out in our large load programs could allow for a third party to come in and serve a customer that's in our territory, a new customer that's in our territory, without harming, because we always say if we start to lose our territory, that's going to harm our customers, our members. And that's the one thing that everybody says we don't want to do. I think we've laid out some processes both at the GNT and the distribution level that would allow for that, where we can say yes, maybe quicker, while still protecting our incumbent customers. So that's a roundabout way of saying we want everybody that wants to come into our territory because it's good for, the rising tide lifts all boats type of thing.
Yeah, I still don't, I don't know that I agree that you do want everybody, but I understand that, I understand the philosophy of what you're saying. I understand.
And Mr. Chairman, if we talk about the risk profile, which you mentioned a lot of times, yeah, I mean, every utility is adverse to risk, right? But we took a risk when we served the coal mines up in the Powder River Basin. Maybe that wasn't quite as risky as a crypto miner or a data center, but when that large load came up, when CBM was booming, our co-op in the Powder River Basin stepped up and served those loads. And yeah, that CBM was probably more risky than the coal mines, but they did it, and they did it in a way that protected their existing customers. So I don't, yeah, we'll look at the risk profile, but if it's going to go into our territory, our certificated territory, we want to be able to work with the third-party generator, with the customer that's asking for it. So there's a way that we can do that without harming the certificated service territory or our existing customers. And again, I can't tell you what that looks like right now within our white paper, but I can have the big brains come in and
Great. I appreciate that.
You bet.
Further questions for Mr. Nicholas or Mr. Taylor at this time? Oh, there we go. Representative Filer, go ahead.
Thanks, Mr. Chairman. I got a couple of questions for Sean or Rocky Mountain Power there. So what I heard was that we want to protect our ratepayers, which I think everybody agrees with that. But then it was also heard about stranded assets, those types of things, which could hurt ratepayers. But when these large loads are paying 100% of all those infrastructure fees, including generation side, where is the risk? That's my first question, Mr. Chairman.
Thank you, Mr. Filer. Mr. Nicholas. thoughts?
Mr. Chairman, Representative Filer, I think that's the point. I think that the cost causer should carry the cost. And that's what we're looking for. So in the case of what we have in Laramie County is they're bringing their money and their checkbooks to build out the infrastructure to carry the transmission. In one case, over $1 billion for power generation and transmission into a project. That's what those are the type of economic development projects that we want. If unless I missed the point of the question, I think that
I don't think you missed the point of the question. I think the concern is that it hasn't been implemented that way. I know that you're saying that you're looking forward and expect it to be implemented that way. I think from Representative Filer's concern, in the past, that makes perfect sense. I take on all of the risk, I pay for everything, and I still can't get to yes. And that's been the concern that we've seen. And same thing in co-op areas as well. Even if somebody's willing to accept all of the risk, pay for everything themselves, you still can't necessarily get to yes. And that's what we've seen and observed and heard complaints about. So any thoughts on that, Mr. Nicholas?
Mr. Chairman, so Rocky Mountain Power, you've all heard this, has that Schedule 400 large load tariff that allows, this is what the special contracts would go under. To my knowledge, I don't know that we've had a Schedule 400 application.
Yeah, it's my understanding also.
And I don't have an understanding of the machinations underlying that as to why. I know that we have offered hundreds of megawatts to customers right over here at Dave Johnson, and they haven't taken it because of location, not because of availability. So
have you put out a call, out of curiosity, have you put out a call and said we have 200 megawatts available at this location? If you raise that sign, we have 200 megawatts, the address is ... Do you really think you'd go a week without selling that power?
I think it's more, when you get into that size scale, it's actually more challenging than you think, because we're talking to the large actual users of data centers, and they say it's too far from an international airport, it's too far from good fiber, it's all of those things.
If you can point Mr. Terranova or Representative Filer to a location where you've got 200 megawatts that can go online, I don't think they're worried about an airport. I think they'll consume it as soon as you can flip a switch. So that's been a problem we've had for quite a long time, is the inability to point to a location where there is any power available, let alone hooking up to it. And then one of the other concerns we've heard is, since if I want to do a project and I want to pay for it all myself, and I'm working with, for example, Rocky Mountain Power, but this is true of anyone, you would be the ones effectively building it out, doing all the sourcing on your priority list, on your timeline. So if a project in Utah was a higher priority project for transformers, then the Wyoming project is behind the Utah project, because you get to set the timeline and the priority. The free market doesn't. So this, again, I can't just say, hey, I'm going to take on all the risk, I'm going to do it all myself, I'm going to build a project and have it done in 2 years. I still have to go to you and convince you to put on the list a project in Wyoming, and your list might be 11 years from now.
Mr. Chairman, there certainly is a lead time problem for all resources when it comes to building out new infrastructure. But I think that we all acknowledge that, and we've said that before. But I think one of the things that we acknowledge is that the private equity has gotten into the electrical infrastructure game, and what they've done is they've clogged up all the manufacturing supply chains, and so they jumped in early and soaked up all the supply. And so when Rocky Mountain Power wants to get in the queue to buy a turbine or a transformer now for a proposed load, they're sitting behind all the private equity people that are speculating on electrical infrastructure, right? And so certainly they're able to move faster. But that's the economic reality we're dealing with.
But-
and
but
so
we're-
some of the legislation here is intended to help.
Right, and,
soften that.
and maybe it will, but we are effectively putting ourselves at the back of the line based on our current system because of the fact that it will be Rocky Mountain Power that builds it using your resources, your priority, your leverage, and your to-do list, where Wyoming is not on the to-do list at this point in time. So we'll go at the end of it. And as you get transformers in, you'll go through your projects. And there's no capacity then for an investor that wants to do economic development that looks at Wyoming to say, all right, we want to locate in Rocky territory. And I've already got a line on the transformers. I've got everything I need. I'll build this in 2 years. That project is a no. Statutorily, it is a no. It can't go forward. The risk is not allowed to go on to the third party. It has to be managed by whoever the certificated territory is governed by. And I think that's part of the concern. And I don't know if the legislation provides a vehicle to work through that, but it is something that we probably need to take a look at. Mr. Nicholas?
Mr. Chairman, I think it does that through providing sort of public-private financing mechanisms to build speculative locations, co-locate, those types of things, which then honestly puts the state's pocketbook. Who carries the risk, right? Should it be Rocky Mountain Power to carry the risk, or should it be the economic development organizations, or should it be the end user? Those are the conversations that we try to line out in this legislation. But I think the timeline issue is a universal problem right now. And I think when I have a fair bit of skepticism when a company, a third party generator, comes in and says, well, we can build you 150 megawatts in 2 years. I just don't see how that's possible. They can certainly say that to get the project, but can they actually deliver on it? I have a fair bit of skepticism on that.
And not to belabor this because we need to get to Mr. Bush, but that's precisely the point, though, with the risk where you shouldn't have to say yes. You don't trust that person. That person says, I can do this in 2 years. You say, there's no way you can do that in 2 years. The answer ends up being, there's no way you can do that in 2 years because Rocky says, we're not even going to engage you. We're going to do our own thing. Rocky is choosing for 2/3 of the state on behalf of the state of Wyoming to deny this person from having the opportunity to take the risk under a free market circumstance. They might have a line on it. They might not. It's going to be hard. I don't disagree with you. That's a challenging project. Good luck. But therein lies the difficulty, and that's where there's no path for that person to develop here. They'd go to Texas or wherever else, but Texas is always the great example. So they end up taking it, they do have a line on transformers. They've got a line on some turbines. They have friends in the right places, and they can build 150 megawatts in 2 years, and they will skip Wyoming, and they will build in Texas or another state where they can build it, and it happens. And I assume that's happened in the United States. It probably doesn't happen often, but we're out of that game. Is that a fair assessment?
Chairman Rothfuss, I hate to do this with a rhetorical question, but I think so if Rocky Mountain Power's timeline is 6 or 7 years for the same project, and so a private company comes in and says they can do it in 2, one, we're denying the broader community the benefit of tying in that load and that infrastructure. I think it's universally known that the Cheyenne community is benefiting greatly from the grid build out that's happening there. But what's the penalty if they don't perform in 2 years? We've denied the community an opportunity to improve and the broader grid to improve and the incumbent utility to improve because someone can come in and promise they can do it in 2 years and then don't deliver. What's the penalty for that? So they can come in and say they can do it in 2 years and don't, and then now they build it in 5 or 6 or 7 years, the same as Rocky Mountain Power would have done, and there's no penalty to them.
Well, there could be. I mean, and that's the difference. I think I'm sorry, I basically trounced on Representative Filer, who had, I know, a second question, and I just ran with his first question for the last 10 minutes. Representative Filer, my apologies.
Mr. Chairman, no need to apologize. You're hitting some pretty good points. I think, you know, when we're looking at this, I did hear something that said, okay, well, if you bring in some maybe third-party generation, somebody can build that out in 2 years. We want to have some type of a deal on a contract within a servicing territory that maybe later on, when we can service it, you got to shut your stuff off. Nobody's going to spend that kind of CapEx. So what I'm going to ask you guys is, would you be willing to understand that if somebody's willing to take that risk, somebody's willing to build out that power generation 2-3 years, whatever it is, or whatever megawatts that they need, and they have to contract that power to the end users only, not to everybody else in your servicing territory, not to use your infrastructure. Would that be okay with the utilities if something like that was in place?
Mr. Nicholas, we'll start with you.
Mr. Chairman, Representative Filer, I think at this point, I think the answer is the same, is that's our certificated territory. That's what we book our business on, and to allow that without at least having the first opportunity to participate and service that project, I think is a problem, because that's how the industry's been developed over the last 100 years. And that's how the public financing of the companies works as well.
Sean, I assume you
Mr.
agree?
Chairman.
Add anything? One second, Mr. Representative Filer.
Yeah, Mr. Chairman, Representative Filer, I believe, and don't, maybe I shouldn't say it on the record, but I think and I'm just kind of reviewing our solutions from Basin and Tri-State, that we would be able to figure something out with that third-party generator. That was kind of my whole point is, so I think my conditional answer would be yes. We would try and figure something out, and I think we have it laid out in our processes now, which have just been approved. We're still waiting for approval. So it's in its early stages, and I know we've been talking about this for a long time, but I think we have gotten to the point where we can address Representative Filer's question. Your concerns have been, I think we're there, but we don't have any victories to talk about yet, because it's all still pretty new. But I think when we get to that point, I don't know that a lot of this other conversation around third party, dereg, whatever, will be necessary.
Okay. Representative Filer, go ahead.
Yeah, thanks, Mr. Chairman. And thanks for that, Sean. And I appreciate the fact that you guys are willing to work with a third party generator. But what I'm thinking of is on a third party generation, that the utility will never have access to power those end users ever, because they're going to spend the money on the CapEx to build out their own generation. And it's going to be a contracted power load between the generator and the end user, which in turn, I don't believe that they would have to use your services, even if you could supply them later on. That's maybe more just a broad statement. The other issues that I'm looking at with the third party generation and maybe access of power is we're seeing it right now. In Laramie County, there's a large generation project that could be easily used down the road, even for more than just an end user. It could possibly help a utility, give them more generation power to run through their transmission lines. Would Rocky and the co-ops be in favor of, if somebody was to do a third-party generation and have access power, would the co-ops and Rocky be willing to purchase that power from that generator for their ratepayers?
Any thoughts on answering that? Either of you? Go ahead, Sean.
Thank you, Mr. Chairman. Again, a conditional answer, but I think yes. We talk about this islanding concept where it is a third party that comes in. They're not connected to the grid, because once you connect to the grid, that's not just on us. There's a whole bunch of other things that you got to take care of with FERC and NERC and getting in the transmission queue. And we're going to have markets coming into Wyoming, the SPP and others. So once you connect to the grid, it's not just us saying, this is what you have to do. It's federal and other entities. So if it's an islanded concept not connected to the grid, which we lay out in our white paper, yeah, I think we have a way to work with those folks to do that.
Thanks. Nate, anything you want to add?
Mr. Chairman, Senator or Representative Filer, I think the concept of islanding is, I don't have an answer for you today, but I can get you an answer for the next
Great.
meeting.
Thank you. Representative Filer, anything else before we go on to Black Hills?
Mr. Chairman, I think the only thing I want to mention is I think what we're trying to figure out is a way of being able to handle a larger load capacity in Wyoming, keep our power here, helps our revenues in Wyoming, helps create jobs in Wyoming. It runs all the way, it runs full circle. And whatever we got to do to help, what I know it seems like sometimes we're beating up on the co-ops or Rocky or whoever, but it's not that we're beating up on anybody. It's we're trying to figure out a way to make a framework for everybody to win. And whatever we got to do to work together to maybe get something done, that would be great.
Thank you, Representative Filer. All right, Mr. Bush, the floor is yours. Please introduce yourself.
Thank you, Mr. Chairman. David Bush, representing Black Hills Energy. I think as most people know, Black Hills Energy is based in South Dakota. For Wyoming, we serve electricity in the Cheyenne area and also a little bit up around Newcastle through our sister utility out of South Dakota, Black Hills Power. But in Cheyenne, we're Cheyenne Light Fuel and Power, which is what we've been for years. Excuse me. And then we also do natural gas distribution through quite a bit of the state. I think, Mr. Chairman, you were the only one here when we first started talking about Bitcoin mining and blockchain, when this was a task force 7 or 8 years ago. And we came up with this concept of a blockchain interruptible service tariff, ran it through this the task force, now the select committee at the time.
And I think Representative Yin was here. I'm pretty sure he came to the task force just like I did, I think. Oh, okay. All right. I'm wrong. It's like you remember better than I do.
I'll take that. So the tariff that we worked on does everything that we've talked about. It protects existing customers, make sure that any of these loads that come on do not impact other customers and in fact benefits other customers. I was just reviewing our tariff that we filed and it's been approved by the Public Service Commission, and it does include a customer credit that goes in there. So every megawatt hour of power that's purchased under this tariff, there's a credit that goes back to customers. And the numbers that I have from 2025 was about $125,000 that went back towards customer bills, other customer bills with that. So, and that's going to grow as we continue to grow our Bitcoin mining customer base in Cheyenne. We do have a couple of customers, Representative Filer is one of them. Another company, Clean Spark, that I know that you've all heard about, and they've put out some media as well. So we're continuing to grow that, as well as the data center load in the Cheyenne area. Again, with the basics of the tariff for the blockchain customers being, we're not going to put other customers at risk. The power is market purchase, unless that customer wants us to build something. Certainly, we enjoy building things for our customers. So if a Bitcoin miner came to us with a checkbook and said, I want you to build me a natural gas plant to serve my facility, we can certainly do that. We're not going to build it on our dime or our customer's dime to serve that load. However, under this tariff, they would have to pay for that. So that's one way that we ensured that we protected those existing customers through the tariff. And I think as the discussion is unfolded, there's a couple of things that I want to mention. The tariffs that we have are designed to, I think, answer some of the problems that are out there with some of these loads that maybe didn't fit into a traditional tariff rate structure that did put other customers at risk, which is why we designed the large power contract service tariff for Microsoft and other data centers and any large load really. And then the blockchain interruptible service tariff as well, designed for those loads. So I think we've shown that we can find a home for these customers that want to come to our service territory and are looking for power. that also continues to protect those other customers and really keeps them without having any sort of risk there. And that's all run through the Public Service Commission. As rate regulated entities, we have to do everything through them and has to be approved by them. And they are very keen, working with the Office of Consumer Advocate to make sure that those other customers of ours aren't put at risk, and really the health of the company as well. Credit ratings and all that stuff factors into the decisions that the Public Service Commission makes, because if we have to go out and get a loan for building new infrastructure, it's obviously better if we have a good credit rating. And so all of that factors into decisions that the Public Service Commission makes when it comes to approving these tariffs and looking at how we're running things. To Representative Filer's, one of his questions about if a third party was to build something and would we buy that power for our customers, I think that also again goes back to our process with the Public Service Commission. We can't just go out and buy whatever power we want. Generally speaking, we have to build a case for why that is the best power to buy. That's generally through our IRP process, where we talk about what power we need for our customers going into the future and what is the best option and least cost option for them. So I would also say, I guess, a conditional yes, but under those auspices of Public Service Commission regulation and that sort of thing. We can't just say, yes, we'll buy that power. To that point too, though, we also have we have a few customers that are using power from other sources that aren't ours. There's a large solar farm south of Cheyenne that's serving one of the data centers. We worked with them. It was originally Q-Cells, and now it's Southern Power that owns that. We have a power purchase agreement with them, so we move that power across our lines over to Microsoft, and are kind of the middleman there, but also provide the professional management of the grid and all that goes with it. Same with the other project that Representative Filer was referring to was the Tallgrass project that is building 2.7 gigawatts, I think, for a data center customer. We worked with them. They approached us, and we worked through the process to allow for us to work with them and really put a good project together that benefits all the customers. And again, to Mr. Nicholas's point, our other customers in Cheyenne are benefiting from that project as well. So there's transmission credits, there's infrastructure improvements, all of that goes into these projects that, working with the incumbent utility, other customers see the benefit to that. So we're happy to continue to work with those customers to come up with unique solutions. We feel like we've been pretty nimble with trying to address concerns that either the regulatory agencies have or other customers have, or the bigger customers that are coming in. Hopefully we'd love to have like a big manufacturing company that would come to Cheyenne. That'd be great too, to have some different, flavors coming in there. But we're all in for economic development for Cheyenne and Laramie County, and doing what we can to provide the service that those customers need and want, including the blockchain customers, which we're happy to see that growing. It was bumpy there to start. I think, as you remember, Senator Rothfuss, there was a few conversations. Texas came up earlier. There was a lot of Texas talk that happened, and I think I'm proud to say that our reliability is in the top quartile nationwide. I don't know that Texas and ERCOT can also claim that. And a lot of these proposals they're very good for large users and at the expense of residential and small businesses. So we're proud that we're continuing to serve everybody and have that reliability as well. So yeah, I think that's it.
I think it's probably fair to say, and correct me if I'm wrong, but you've effectively incorporated large projects through your tariffs in a way that not not only didn't hurt your traditional residential customers, but really helped them. I think it's fair to say that because of the additions of the large power that you've put on grid in and around Cheyenne, the rest of your grid is healthier and more robust for your customers. Is that fair?
Mr. Chairman, it is. That's part again of the process with the Public Service Commission and OCA and others, is that requirement that these large loads pay for the infrastructure that they need. We're holding our other customers harmless. And in fact, there is that benefit. The numbers that I have was about $2 million of credit transmission. It's basically a credit that gets paid by the amount of usage, same as the blockchain, except it's just at a bigger level because there's more power being moved and the numbers are a little different. Spreadsheets are not my thing. So, but that's what they tell me. So it's about $2 million that's been credited back to customer bills. I think that was a 2025 number as well. So again, it's a huge benefit to our customers in the Cheyenne area. It's something that we're very proud of and the ability to work with them. It hasn't always been easy. I mean, that's, like I said earlier, we started out, it was pretty rough with some of the Bitcoin miners that were coming to us, and we didn't have a solution for them that really worked for them or for us or the commission. So we think we're in a pretty good spot now and feeling pretty positive about how things are moving forward. And again, I guess I would say, different customers than other large customers in my colleagues' service territories. But I think overall, the utilities do a good job of trying to work with whomever we can to come up with solutions that benefit them and also protect our existing customers.
Great. Thanks. Any questions for Mr. Bush? Questions? Go ahead, Representative.
Mr. Chairman, thank you, Mr. Bush. Do you know, like, how often on average do you ask to interrupt the service for the interruptible tariff?
Mr. Bush?
Mr. Chairman, Representative Yin, I don't know that for sure. I'd have to ask my folks to see how often we have to interrupt them. I know it's a pretty quick and easy process if we have to, but I don't know the frequency of that, so I can get that information for you.
Thanks. Any
I
follow-up?
can give a little insight on that.
Yeah,
Mr.
I was going
Chairman.
to say, Representative Filer, I bet you know directly.
Yes, Mr. Chairman. So it could happen on 5-minute intervals. So, as we see the power prices and load factors are about every 5 minutes, there's a different interval. So Black Hills has been able to put in a process working with the curtailable load power that they have in the Cheyenne area to where they can actually do that by pretty much a push of a button. They can actually shut our power down and bring it right back up in 5-minute intervals or whatever it is for the needs at those different times where, like my load factor with High West Energy, they get 450 hours of curtailable load a year, but it's very sporadic. You just never know when it's going to happen. And they just send you an email, then we have to be there on site. It's a lot more of a process. But yeah, Black Hills is very proficient with it. They hit a market rate, whatever that might be, curtails the load, or if there needs to be an excess of power or something like that, because as we know, our curtailable loads are more like a digital power station for them also.
Excellent. Thank you for that. Any questions, Representative Yin? Okay. Okay. Any further questions at this time? All right. Seeing none, thank you all. Appreciate all three of you for joining us and staying late. My apologies for going as long as we have. All right. Any further public testimony on this topic? Any further? Do we have anyone online?
Mr. Chairman, Mr. Marr raised his hand.
Okay, Mr. Marr, let's bring him on.
He'll join us shortly.
Great.
Hi, can you all hear me now?
Yes, we can.
Yes, sorry about that. We need to send a note to Zoom or something. Brendan Marr, I'll be very quick and succinct. What I'd like to speak about is the economics of data centers. I might want to shed some light on those economics because I think it will be very useful. A lot of times the risk is not even monetary; it's just a matter of time. Data centers are built out based on the space that they have and the number of servers that they can put in, and those servers they basically come out on a essentially a yearly basis or so, and that their specification determines the number of tokens that a data center can generate. That is tokens, I mean AI tokens, and that determines all of the economics. And while many people think that, oh, the servers get deprecated in 3 years, that's not even the case currently. The current thinking is that the deprecation is about a year and a half because the rate at which the servers are increasing their capacity. So by the time the next round of servers come out a year and a half later, the other round is completely deprecated. It's they're nowhere close to the capacity that they were operating at. So therein lies the problem for data centers. I mean, it's just a matter of getting the electricity up and running in the shortest amount of time. I hope that's helpful.
Yes, thank you, Mr. Marr. Any questions for Mr. Marr? All right, seeing none, thank you once again. Appreciate your testimony.
Sure.
And sorry, Ms. Levin, I didn't go back to the room before going online, and I am happy to see you and welcome. Please introduce yourself and what can we do?
That's okay, Mr. Chairman. Thank you. Jody Levin. I'm here on behalf of the Trona Industry and the Wyoming Mining Association. I just wanted to clarify for the committee, the topics before the Joint Minerals Committee and the Joint Corporations Committee are interim topics that were requested by the Mining Association and the Petroleum Association, because well before we have crypto mining and we have data centers with increased electricity demand, your legacy industries are having real problems with capacity, with price, with reliability. And so the solutions that are being talked about, or the model that has served our nation for 100 years, isn't going to solve our issues. We're not going to have the capacity that we need if we keep the same type of structure. And that's no fault of the utilities. They can't build out the infrastructure fast enough to meet market demand. So the problems that we're having, we have a speed to market problem. Wyoming is missing out on opportunities within your extractive industries because we can't get power. So that isn't a topic that is necessarily, this committee looking at that, but I did want the committee to know that this is a real concern of your legacy industries. And that's why we've asked for that topic before both of those committees. Minerals looking at it in terms of a barrier to energy dominance. We see the #1 barrier right now as a lack of electricity. And in the Corporations Committee, it's on reliability. We're seeing more and more power disruptions that cause significant damage to facilities, but also a loss in production. So we too are in this camp, but we're in this camp well before you get to 100 megawatts.
Absolutely.
And we need solutions.
Thank you, Ms. Levin. Any questions, committee? And
Mr. Chairman.
with this, yeah, go ahead. Representative Filer.
Yes, Mr. Chairman, and I didn't mean to. If you want to ask your questions first, that's fine. I can.
No,
wait.
please go ahead.
Okay, and Ms. Levine, I appreciate what you're saying about our core and legacy industries being stifled back because they can't have the power to generate what they need as far as being a production or a producer here in Wyoming. So I would like to ask you, would it be fair to say if there was a way that we could do some type of a third-party generation system to where you can bypass your utility if you guys are the end user, would that help your industry at all?
Ms. Levin?
Mr. Chairman and Representative Filer, that is the exact solution that some of the companies are asking for. I can't say all of them. Some of the companies will still want to connect to the grid, and they will pay higher tariffs, backup power tariffs, for that capacity, but some are absolutely looking at doing an island situation. So it's a mix of both.
Any follow-up, Representative Fowler?
Yeah, Mr. Chairman. So what I'm thinking, so I had a bill last year. I think most everybody read that bill from last year, which was a third-party generation bill to kind of make an island where you have, 4 or 5 different end users, and that's it. It doesn't hit the public utility side of it, and it's not regulated as a utility because it's contracted power and it's only 1 to 5 end users. But there was also a megawatt limit on it, or had a minimum. So if we was to look at something like that, what would be that megawatt minimum that you would need?
Seeing none, public comment is closed. Back to the committee. Committee, I didn't anticipate any action on this at this point in time, other than what we've discussed, carrying it over and considering continuing the conversation as we know more in September. So that's my current expectation. Does anyone have anything to discuss or any further thoughts? Yep, Senator.
Thank you, Mr. Chairman. I'm just wondering what our end goal is. I mean, is it edification, education for the committee? Are we planning on doing legislation? Or are we I just don't want these nice folks out here to have to go to 3 separate committees on the same topic unless we have a separate goal in mind. Just curious what your thoughts are, Mr. Chairman.
Thank you, Senator. And I think they love to come to 3 separate committees. Honestly, I think this is one of their highlights. This is a fave. But Senator, I think we do have a priority, and honestly, I don't know what the other committees are going to do. As I said, I serve obviously on the Minerals Committee. Representative Yin serves on corporations. We've been looking at this on Minerals Committee for quite a while and haven't really taken any serious action in the end. I don't know that we will this time. And I could tell you on the Minerals Committee, I think it's fair to say, and I think my friends out here would agree, I'm probably the most concerned member of the Minerals Committee on this topic and have been the most active on it in the past several years. So I want to see the Minerals Committee bring forward what they're working on, bring legislation from the Minerals Committee. But if the Minerals Committee does not take action that is sufficient, then I want this committee to be prepared to take action that is sufficient. That's my interest, is that a high quality bill that is well vetted, thoughtful, and incorporates stakeholders ends up going to this legislative session. So there you go.
Thank you, Mr. Chairman. I am quite confident in this committee's ability to bring forward good legislation.
I think so.
And I'm enjoying learning about it. So thank you.
Excellent. Absolutely. Any further discussion on this topic? Seeing none. Let's go to Talise and Clarissa. Any questions, any directives, anything you need from us? I don't think we have any further directives, so all good? All right. Clarissa, everything good? Okay, and we are meeting again. Let's talk about the next meeting. What are our dates on that, Clarissa?
Yep, Mr. Chairman, we're meeting in September. It's September 28th and 29th, and we will be in Laramie for that meeting.
In lovely Laramie, Wyoming, where the weather will be better. And we look forward to seeing you all then. Thanks, everybody. Meeting adjourned.